Yeah. Yeah. So, okay. Yeah, sounds good. All right, good evening, everyone. Welcome to the April 17th, 2025 Planning Commission meeting. Our first order of business is the Pledge of Allegiance. The Pledge of Allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone. And again, welcome to tonight's meeting of the Credit River Planning Commission. We're a group of your local residents and neighbors appointed to serve the community by reviewing development proposals and land use matters in accordance with the city's ordinances. As a quasi judicial body, our role is not to advocate for or against any proposal, but rather to ensure each application is reviewed based on the facts presented, applicable law, and policies. Our goal is to uphold a process that is fair, transparent, and consistent. Public hearings are a vital part of this process. They provide opportunities for community members like you to speak, share concerns, and offer input into the public record. Your comments are important and help us shape the future of Credit River. The following is the general order for public hearings. Staff will present a summary of the project along with the staff report and findings. Commissioners may then ask questions following the presentation. Second, the applicant will have the opportunity to speak and to respond to questions from the commission. The chair will then open the floor for public comment. And if you choose to speak, please come to the podium, clearly state your name and address for the record, and limit your comments to 3 minutes. Please keep your comments focused on the matter at hand, and please be respectful and constructive. Step 4, after the public comment, the hearing will be closed by the commission, which may then hold further discussion and consider possible action. Please note that we are a recommending body only. We do not have the authority to approve or deny applications. We serve as the recommending body to the city council, who will make the final decision after considering the commission's findings. So we thank you for being here this evening and for taking part in the process of your local government. With that, I will move that we consider the agenda for tonight's meeting. All commission members have received a copy of tonight's agenda, which includes 3 public hearings under general business. I would take a motion to amend or approve the agenda accordingly. Does anyone have anything they would like to add to tonight's agenda? Seeing none, can I get a motion for approval?
Move that we approve the agenda as presented.
I have a motion. Do I have a second?
Second that.
Motion and second. All those in favor, please signify by saying aye.
Aye.
Okay, motion carries. On tonight's agenda, we do not have any items under number 2, the consent agenda. That brings us to item 3, which is the public hearing. So on tonight's agenda, we have 3 public hearings as follows. Request for comprehensive plan amendment to re-guide 6 properties from urban expansion reserve to commercial. Zoning amendment rezone application for property ID 0490-80030 from urban expansion reserve to industrial and commercial. And preliminary plat application for Credit River Business Park. I'd like to ask City Attorney Michael to go ahead and provide us with some instructions.
Michael, 1 second, I think, just, I think it's on.
Oh, sorry.
Yeah, forget, you're gonna, thank you for that. Unfortunately, I think, even though I'd love to participate, given my home is surrounded by the, property in question tonight, and I think it's only appropriate that I abstain from voting and not participate in the discussion. So I wish you guys luck. Thank you.
Thank you. All right, with that, City Attorney Michael.
Thank you, Chair Olson. You have, as you said, 3 hearings tonight that are related. The applicant is the same But I want to reinforce a couple of things, largely around what you said at the beginning, which is for each one, hear from staff, have questions, hear from the applicant, have questions, then the public. While they are related, each one of them is separate. The comprehensive plan amendment is a legislative kind of choice that the city will make. It does not depend on a specific plan. They have provided a plan that you may well want to ask a lot of questions about, but we're talking about the city's guiding. The next two items are related. And so what I would like to reinforce for the panel is, as a recommending body, you're of most help to the city council if you thoroughly examine each of these applications. And taking it in reverse order to try and make my point, the preliminary plat would require a zoning change. You may or may not recommend a zoning change. Regardless of how you recommend that, it's still important to evaluate the entire preliminary plat so that if council perhaps disagrees with your recommendation, they have the benefit of all of your analysis. Same for the zoning change. And so roll up your sleeves and work through each one. If there are legal questions, I'm available. I am not here to advocate any position one way or the other, but to be of assistance to the panel as needed. Thank you, Chair.
We appreciate it. Thank you. Before I open the public hearing and we hear from our applicant, I'd like city staff to summarize the ordinance, summarize the application and offer relevant background, please.
Sure thing, Chair Olson. Good evening, planning commissioners. So first public hearing and application I'm going to give a brief summary on this evening is for the comprehensive plan amendment. The property owners have requested to amend the future land use map on page 219 of the city's comprehensive plan to re-guide subject properties from urban expansion reserve to commercial future land use designations. The exact PID numbers are listed in your staff report or in the planning staff report in your packet. Re-guiding the subject properties would allow for this owner to develop a modern rural business center with a mix of uses that are consistent within the city's commercial land use designation. They at this time would be served by independent utilities today that would then be hooked up when municipal services come available. A mix of uses would be anticipated, including some general business, light industrial, and rural commercial uses. And the location of the mix of these uses will be further determined when the development continues review process, et cetera, what the market drives. At this time, we don't, for this particular application, have what those specific properties would be. The proposed re-guiding would add approximately 139 acres to the commercial land use designation of the city. And I'll just read briefly, and it says in my staff report, what the comprehensive plan says for the future land use commercial designation is. This category provides for typical commercial uses such as retail, medical, offices, and service businesses, or light industrial uses. Minimum requirements are that several parcels guided commercial already contain commercial uses on the property. Development may occur on other parcels prior to the extension of municipal water and services, provided that development occurs in a manner allowed under development regulations and is designed to accept future extension of municipal services. And that land use category corresponds with commercial or industrial within the city's zoning code. If you need to look back into that throughout the remainder of this meeting, that is on page, wow, it's a long packet. I think it's on page, I don't have the full packet up, but it is on page 3 of 10 of the planning staff report, just for your reference throughout the conversation. And with that, I think I'm happy to answer any questions, but that's the general broad overview I can provide at this time.
Are there any questions at this time that the planning commission members have? All right, seeing none, I would invite the applicant or their representative to come speak.
You're the driver?
Yeah.
All right.
Good evening.
Good evening, Madam Chair, members of the commission. It's nice to be with you this evening. My name is Jennifer Haskamp. I'm the owner of Swanson Haskamp Consultant. We are an urban planning firm out of St. Paul. I'm here on behalf of Messenbrink, which is the applicant before you this evening. I've prepared just a very short presentation because I understand we have a lot on the agenda this evening. So I believe the last time I was here, I was a bit long-winded, and this time we're going to be quite short. So next slide, please. So to give you a sense of where my presentation is going to head, I'd like to talk just a little bit about the application framework and what is guiding your decision-making this evening. A little bit of a response to the staff report that was provided to us. A little bit about Messenbrink's continued commitment to Credit River and to this project, and some of the offerings that have been made over the last year and a half or so as this project has progressed and wound its way through various court proceedings, et cetera, and then where we arrived this evening. Just a brief overview about damages. However, Jack Perry, who's with me this evening, which is our counsel, is also going to speak with you just a little bit after I'm complete. Next slide, please. So in terms of the overview of the framework by which you have to make your decision this evening, it's a little bit unique and unusual, as you, I'm sure, are all aware. So typically when an application comes in, you simply look at your ordinance, you look at your comprehensive plan, and you assess the merits of the project against those plans. As it stands, there is a judge's order that was issued and was provided in the packet this evening. And so it behooves us to look at both in conjunction with each other. And so from that perspective, we've got two documents or three, depending on how you look at it. We've got the judge's order, and then we also have your adopted 2040 comprehensive plan, and also your zoning to a certain degree, although your zoning is your implementation of that comprehensive plan. There are certain city arguments that were made in terms of the denial that the judge has already essentially deemed rejected, for lack of a better way of saying it. So some of those arguments that were incorporated in the order did not make their way into the staff report. We want to make sure that we touch on a few of those. That lack of review against the judge's order, especially when it comes to some of the findings for denial, I think warrant further discussion, or at least to bring to light in terms of the Planning Commission's consideration this evening. And then finally, the judge's order was pretty clear that the damages are recoverable unless and until you fulfill your duty, because the order essentially said we needed to be here tonight and talking to you once again about this comprehensive plan amendment. So as I stated, there were certain city arguments for denial that have already been rejected by the judge. I basically put them into a couple different buckets for purposes of discussion this evening. So the first one related to the premature findings is that the judge determined that the commercial and industrial land use designation contemplated that development could happen, in fact, prior to the extension of MUSA. So it essentially negates the argument for premature from the standpoint of your comprehensive plan did, as Claire just read, contemplate the idea that there could be commercial and industrial development in non-urbanized or not hooked up to MUSA service areas. So your comprehensive plan already says that. And so the idea that it's premature is related to that extension of MUSA, but you've already contemplated for how that could be accommodated. Secondly, since the judge determined that you contemplated commercial and industrial uses, there would be little to no area within your town in which the adjacent land uses would be seen as compatible or not inconsistent from the standpoint of you don't have much land already guided for those land use designations. And in fact, your comprehensive plan does denote the fact that we would need to go through this exact process, which is essentially asking you to change those land designations as a project arises, which is how we got here. Findings related to the inadequate road connections, ignore Messenbrink's continued conversation with all the regulatory authorities having jurisdiction over the roadways to find solutions of how those connections can be made. The intersection design, which you'll take a look at in upcoming applications, was actually we received those from the county, which is where the main entrance and access would be. And that intersection design was actually solicited from them and provided to us. And so it ignores this idea that we haven't done our due diligence, that we haven't talked to all of these authorities, and also talked about the fact that we understand that this would be a phased project. And so the comprehensive plan area is larger than the phase one, and phase one is what you will consider in subsequent actions this evening. And then finally, there's some findings or references to the fact that there are unknown conditions of whether the project could stymie the future hookup to those MUSA or water services. And at the end of the day, we've stated repeatedly that we would design the project in such a way, including putting pipes in the ground where they could be hooked up to MUSA in the future. So the idea that we simply don't know is not accurate, because we intend 100% to design this in such a way that it can be hooked up and it will not thwart your efforts to create a town center or MUSA, urban sort of area in your town at some time in the future when desired. There's also been a bit of a lack of reference throughout the staff report to Messenbrink's written and verbal commitments to the project and to try to make this work. I think they've repeatedly made efforts to extend all of the olive branch, for lack of a better way of saying it, to say, how can we do this in such a way that it could be compatible with the neighbors, how it could meet your goals and objectives for tax base and diversification of land uses that are identified within your comprehensive plan, and how might we do this in such a way that everybody wins. They've done that, I think, throughout the entire project, including through the court proceedings and offers for settlement negotiations and discussions. And so it just has been slightly overstated that Messenbrink hasn't come to the table, because they've come to the table repeatedly. They've even talked at certain points about whether or not this would be an appropriate place for City Hall and how that might be incorporated and integrated in. And so from that standpoint, I think those were very early in the conversations. It was thought that there might be some traction there. Somehow that fell apart, but that olive branch has continued to be brought up throughout the process. And then finally, we understand that we have adjacent neighbors, and the goal is to make sure that we can do this in such a way that it respects those neighbors to the greatest extent possible. Some of that comes in the next step in terms of, as individual sites develop, and we've got custom building pads here. As those develop, that's the appropriate time to figure out exactly where screening is located, landscaping is located, because we'll know where those parking lots are. We'll know where some of those loading areas are. And then you design those improvements to reflect those particular building orientations, et cetera, to best protect the neighbors. And so if we did it today, when we don't have those buildings, it may not achieve the desired outcome. The other piece is we did provide quite a bit of screening and especially around the perimeter to try to get at some of those concerns. But Messenbrink, it continues to be open to how we can best integrate this development in with the adjacent neighbors, understanding that there will obviously be concerns and we understand that and would want to work with you. So the last piece of the damages, which are not my area of expertise, which is why the attorney is here. So as a planner, I talk about land use, I talk about development. Damages are a necessary evil as part of this because the judge's order said that it was. So from that perspective, the only thing that I would say to you is that basically the clock keeps ticking. So until a decision is made, we would say a decision is made in the affirmative, the damages will continue to accrue. There's obviously a loss opportunity cost in terms of the market. So what might have been very viable when this whole thing started may not be viable today. And so those are real damages. Mess and Brink has verbally and in written form expressed willingness throughout this to continue to collaborate, to respond to concerns. We reached out to try to have mediation, et cetera. And so from that perspective, I think we've tried to stop the clock, for lack of a better way of saying it, and tried to find an amenable solution, but have been unsuccessful, which once again is why we find ourselves here. And so your failure to follow the plan initially is what caused the damages from a development perspective and from a timing perspective of bringing those developments online. So from that perspective, the only way to cap the damages or stop them, if you will, is to approve the request. So next slide. So finally, because I'm not the legal expert, I always joke, I just play one on TV. I will bring the real one up, which is Jack.
Madam Chair, members of the commission, Jack Perry from the Taft Law Firm. And I've submitted a couple letters. They're in your packet. I handled the underlying dispute on this. I was there for the mediation we had with a retired judge to try to settle this thing before the court's order. I personally made the offer to immediately have a mediation after the order came out to try to resolve this thing. And I have repeated on a weekly basis with the League of Minnesota's outside counsel, who's a friend of mine, that we need to settle this thing. And we have put that in writing. The Mess and Brink's consultant has reinforced that, but the damages, just so you understand, and we tried to warn the city of it, and maybe it's my fault for not doing a better job of it, but the denial on November 20th of 2023, roughly 18 months ago, 19 months ago, created a absolute worst case scenario for damages. And it did so because Mess and Brink has a specific type of buildings that they create that have been a hot item around the Twin Cities. But as soon as this group or the city council denied his plan amendment back on November 20th, that caused a competitor just a few miles over the border into Prior Lake to do the same thing. So, and it's a finite market, which meant that the customers that Mr. Mess and Brink and its construction company would have sold to bought there. And so the damages are huge. And I say that not as a threat, but just we need to sit down and start working at how do we figure that out. That's in the damages. I have 3 points tonight. I'll make them pretty quickly because last thing anyone wants to hear about in these things is from a lawyer, but because this is a remand from a district court judge, it is radically different from anything that any lawyer or land use planner has ever dealt with before. And the judge not only remanded and said, you have a duty, the city has a duty to look at this application again, to redo it based upon what's in the plan. He also gave 43 pages of explanation as to how he sees your plan. And he didn't just say to do, no offense to Ms. Stickler and her report, he didn't say you get to start all over again. He said, here's the plan, and here's how I'm interpreting this. And the biggest thing he said was you had relied on, when I say you, I mean the city and its denial. You had relied upon an attachment to the plan, which is called a build-out plan. You can't do that. That's not an official part of the plan. Second thing he said was that you rely upon the requirement that was read into the plan that said, hey, you have to have the MUSA line, the water and sewer to the property before you can approve it. He said, that's not what the plan says. Instead, what he said was that the plan is exceedingly clear. He quoted several different provisions of it that said that on December 2nd, 2019, effective January 1, 2020, just before COVID, for those trying to keep track of time, the city adopted for its 2040 plan essentially what Scott County had before. And I think it was, by all accounts, a rush deal and not necessarily thought out the way everyone wanted to. But in that plan, the city committed itself to providing for encouraging commercial and industrial development. And in fact, the build-out plan, which was attached to it, shows that the south part of this plan, this was anticipated to be commercial. But that's what the judge found. And you can disagree all you want, but the judge says you cannot interpret this plan in any way that precludes commercial and industrial re-guidance and rezoning. You can't do it. And now, your lawyers may say, I don't know what your lawyers have told you privately, and nor do I want to hear, because that's unethical. But your lawyers may disagree, and they may say appeal it, and maybe appellate court can change it. But what this judge found was that's how he reads your plan. And unfortunately for you, just so you understand the context of this, is that if this group recommends denial, the city council denies the step one, which is the plan amendment, we're going back to that same judge. And guess what? Most judges, particularly most male judges who are stubborn and petty and like all of us, not that he is, but they're, yes, I realize that. Judges are highly unlikely to reread something differently unless you put something different in front of them. So the only way I believe that the city can get out of this pickle is in the appellate courts. And that's a long ways from now. But anyway, it was remanded back to you. It's a unique situation. And there are, based upon my read of the entire 200 and some pages, there's 3 undisputed issues, or concepts, if you will. The first is that these 3 applications actually work as a domino effect. Is either we win all 3 or we lose all 3. And if we get the yes on the comp plan amendment, that essentially forces your hand, and I didn't see anything different in the staff report on the rezoning. And that rezoning forces your hand on the plat application. So it all goes in order. I just didn't say, I'm not trying to put words in your mouth, but I just don't think there's any dispute on that. The second thing that is undisputed, second of 3, is that, and this is only found in my opening letter to you, is the plan amendment. Appellate courts, including the justice from the Supreme Court that I worked for decades ago, they're always very concerned when courts remand something back to another body, in this case, a quasi-judicial body. And what they're afraid of is that remands are not the opportunity to start all over again. And that's my objection to the staff report, is it's like it's a starting all over again. And so the appellate courts and the district court judges have been very clear, when you remand it, you're limited. You don't, it's not was it Tablo Rossi, whatever. There's not a clean slate. You are limited by the appellate court systems, the Supreme Court decisions that are in my letter, to the reasons and concerns you raised on November, you as in the city, on November 20th, 2023. You don't get to start over. So if you said A, B, and C are our concerns on November 2023, you can't say D, E, F now and deny it that way. I put that in my letter. I gave the cases. There is nothing in the packet from either your city attorney or your appellate lawyer. I know Jason has deferred primarily to you, but there's just nothing in there that refutes that. That's what the Supreme Court has said, is that on remand, you're stuck with what you were concerned about on November 20th, 2023. My letter then went through each of those three concerns, I think it was 3 or 4, that you raised on November 20th. And the judge didn't rule on those 4, but he made it pretty clear that none of those 3 or 4 is going to survive if it goes back to him. So then we turn to the third issue, which is Ms. Stickler's attempts, setting aside the second point. Ms. Stickler did this as if we were starting all fresh from November 20th, as if the judge's order didn't exist, which is just fine. And I'm sure Ms. Stickler was directed to do that. But she went back and she said, okay, here are the reasons that I could see where you could maybe sort of kind of deny this as to the plan amendment. And Jennifer was up here, and Jennifer does the same thing that Ms. Stickler does for a number of cities. And so I asked her to, okay, let's look at those reasons. Do those hold up based upon the judge's order? Because if you saw Ms. Stickler's report, she didn't look at what the judge said. She was instructed, I'm sure, just to look at what the plan said. She didn't look at the order. Jennifer looked at those reasons that Ms. Stickler gave and the judge's order to see if those were contradicted by the judge's order. Because at the end of the day, you don't want to get slapped down twice by a district court judge, particularly one who's willing to write a 43-page opinion. And so Jennifer went through that, and for each of the reasons, the 3 or 4 reasons, depends how you count, that Ms. Stickler identified in the staff report for reasons you could. And she didn't say you should, didn't say you shouldn't, but she gave reasons you could under the plan. Each one of those, as Ms. Hashkamp went through, has already been commented on by the district court judge. And so you are free to recommend to the city council, let's identify those and let's deny it for that reason. The problem you have is that if you look at the order and compare those two, it doesn't look good going forward. And so your only hope is, well, okay, Judge Wilton's going to do the same thing because males don't usually change their mind, particularly judges. So then your hope is the appellate court. Based upon those 3 undisputed items, my hope is that you approve this. My last point is as it relates to damages, to underscore that you have a unique opportunity that closes as of, I believe, May 5. You have a client who is paid an enormous amount of money. He will tell you, if he was here, he would complain about how much he's paid me and our firm to get the order that he got. Despite his legal fees, which are not recoverable, despite the fact that he has $10 million in provable losses because he lost out on this opportunity, he is in writing, and I think he's talked to anyone who will listen to him with the city, and reaffirmed he will compromise on that. His goal is to get his approvals, get the project going forward, and he's willing to compromise because 1, he's a citizen here, 2, he's made a lot of money elsewhere, and 3, he's a good guy. And he has offered multiple times to do that. And on top of that, he offered before any of the applications went in to give some of his property to the city for City Hall. I don't know if that's still on the table, but he offered that. He has asked after the order came out to have a mediation to try to settle this thing. That offer, understandably, is on the table through this process. But even John Messbrink has his limits, and if he has to go back again and spend more money on me, which I like, he doesn't. That offer is going to be non-existent. So I beg you guys to do what the law requires, do what the court's order requires, which is to approve this first application, which requires the approval of the next two, and sit down with Mr. Messenbrink. Or if you don't trust him, do what he asked, stop the proceedings, go find a mediation and settle it and figure it all out, which is what he asked to do. So you didn't have to just trust him. But if you're not willing to stay things so that you can get a settlement, which is our preference, so no one has to guess as to people's good faith or bad faith. If you're not willing to do that, then please approve this, let this litigation drama end, find a solution. And we have a client who's willing to do that. And I just don't know. I don't know how you say no to that. Thank you.
City Attorney Michael.
Good question. I'm sorry.
No, I was going to speak to the panel. Thank you, Jack.
Panel, do you have, before we do that, do you have any questions for the attorney?
I have a question. Sorry. Can you? Sorry, I think you go back. Now with the letters that you sent, is that the March 10th, 2025 letter that you're referring to?
And an April 1.
The April 1 letter?
Yes.
And the March 10th letter, that has 3 items that you're saying the judge says we're supposed to be looking at. That's
Madam Chairperson,
I think that's your, I guess the 3-part factual background is how you listed that.
correct.
So it's those 3 things that are the items we should be looking at.
Madam Chair, Commissioner Theobert,
Theobert.
I'm going to look at it real quickly to make sure that I am saying yes to that which is true. Okay, it's the March 10th letter, March 10th, 2025, and it's on page 10.
3-part argument.
Yep, but the first part is the one that I think, to be very specific to your question, Commissioner, is that I did not paraphrase the judge's order. I also attached the judge's order. I quoted the sections from the judge's order, so you didn't have to worry about whether I'm one of those lawyers who perverts what's actually said. But so I quoted those sections, and those are the 3 items that I think are relevant to this proceeding.
Thank you very much.
Thank you.
Any other questions for the applicant's representatives? If not, City Attorney Michael.
Thank you, Chair Olson. Commissioners. I think Mr. Perry would agree that we lawyers sometimes disagree with each other, and that's the way the world goes around. So there's a couple of things that you've heard that I see differently, and that the lawyers representing the city in the litigation see differently. And I'm not going to speak to any of the merits, with the exception of the things they mentioned in the judge's order. But first off, the remand from the court, and the reason that it's been remanded is because there is a procedural step that the court found the city missed. The court said our own comp plan requires us to review a proposed amendment to that plan against the plan. And that the court found wasn't done, looking at the record. And so the court specifically said more than once that the court was indicating no opinion whatsoever on the merits of the case. you are free to do your work as usual, to evaluate the merits of the application. Having followed the procedure the court said was missing, and which Ms. Stickler and the planner for the applicant have attempted to help you with by looking at the comp plan. And as I think the materials from both the city planner and Ms. Haskamp demonstrate, there are multiple competing policies at play in the comp plan. Not all the arrows point in the same direction when you look at each policy. At the end of the day, the question is, how much commercial and industrial development does the city want in the city beyond what it already has, if any? And deciding that by wrestling with these things that are in the comp plan already, these policies. It's hard work, and I don't envy your position, but that's what you need to do. A couple of points that Mr. Perry made that I'm going to agree with for sure. It's my legal opinion for you, and I think it's consistent with some things the court said, even though it did not make any decisions on the merits. It's not okay to say you don't have municipal services yet, therefore you can't develop. That's not okay. That's not part of the analysis. If you find that their submissions suggest that they can engineer this in a way that it works well on septic now and will connect later, box checked. That's not the only issue that might relate to prematurity. And one of the policies in the comp plan addresses that as well. So these are competing concepts. The discussion of damages and settlement offings and stuff like that are important considerations for another venue and another set of decision makers. That is none of the planning commission's business. And when the city council is sitting as a council to review this application after you make a recommendation, it's none of their business in that setting either. You have a duty to the applicant and to the public to apply the laws and the ordinances and your best evaluation of the comp plan and make a recommendation without any consideration of things outside of those boundaries. I would not be swayed in any way by suggestions about what a judge may or may not do when this comes back to the judge. Just do your best by your own lights. And then Mr. Perry referred to some case law about quasi-judicial proceedings, which is kind of a fancy term that we lawyers use. And so I want to set the record straight. One of the applications before you, the city is sitting in a quasi-judicial capacity, and that's the preliminary plat.
Okay.
When we talk about the comprehensive plan, and when we talk about zoning and amendments to those, we're acting in a legislative capacity. The city has broad discretion to pass legislation on any rational basis that it sees to be in the best interests of the city. And Mr. Perry alluded, I believe, to the dominoes and how these are related. That's why I encouraged you at the beginning, fully vet each one. If at any point you go from green light to red light, keep going for the benefit of the council in case the council sees it differently as you proceed through. And I'm available for legal questions as they arise, but I really would like to stay out here minding the boundaries while you all do the hard work.
Thank you. All right. At this point, it is time to open the public hearing on item 3.1. This is the time for residents to provide comments pertaining to this application. Before I open it up, staff, have we received any written comments?
We have, I think it would be best if I read those at the end in case some that wrote in attend tonight and speak.
Okay.
So I'll do that at the end and keep track.
That sounds great. Please remind me if I
Yeah.
missed that.
Okay.
Okay. At this time, are there any residents present who would like to comment on this application? If so, would you please sign the sheet that is on the table over there? And then please approach the podium. Is there any? All right. Good evening.
Good evening. My name is Tina Mishka and I will fill out the rest so that you guys don't have to wait later. 16331 Creekwood Drive. I don't envy any of your positions right now. Just want to put that on the record. My question, and maybe something for you to think about, is I'm not here to say yes or no, I'm for or against what's been presented, but I think what's important, if this does go through, a lot of people are worried and will be concerned about the density requirements that the Met Council has been pushing. So if this gets developed or approved over here, we have to think of a city as a city, where are all those density requirements going to be placed? So that's the first thing that I had to say. The second thing, because I'm curious, so the lawyer, Mr. Perry, I'm not sure if we are allowed to know this, but maybe just them. You said that there is going to be an offer presented and that we can take it, and we have a due date of May 5th. Do we know what that offer is, or?
Excuse me, I'm sorry, I need to intervene. During the public hearing, it's important that you direct all of your comments, and if you have any questions, to the chair.
Okay,
And if the panel sees fit to ask questions based on that of the applicant, the panel always can.
okay,
Please don't directly address the applicant, anybody. Direct your decision, your questions to the panel.
thank you for clarification. So, yeah, my question would be, is that something that the public can know about what this offer is? Because I'm just curious. So, is that something you can answer now, or?
How would you advise we handle that? Should we save that for questions?
Madam Chair, I would recommend that the planning commission not indulge its curiosity into subjects of settlement, because all of that is out of bounds for the decision that you need to make.
Okay.
That's my advice. These are your decisions. And I know in this city, there's a lot of really good engagement between the public and the panel. The public hearing is a right for each of them to tell you what they think. It's not a right to ask questions. I'm not saying you can't ask questions, but there's no obligation to answer questions. So that you understand all of that when you decide how to respond. You may, but it's just not it's not part of the right of the public hearing.
Thank you for that clarification.
Okay, and then my last question, even though you don't have to answer it. Since David recused himself, so is this just a 4 vote then? Okay, so what if it's tied? Oh,
Procedurally, how do we handle that, council?
Fortunately, you're a recommending body. It will not matter. What matters is that you tell the council what you think. And if you tell the council you're split, and here's the reasons why, that's helpful to council.
Okay.
Don't be split though. Sorry, a little levity. I apologize.
all right, that is all my questions, comments, and thank you for presenting, you guys too. All right.
Is there anyone else who wishes to speak this evening? please go
Yeah.
ahead and fill out the
I'll fill it out.
form afterwards.
Kathy Hall, 17570 Murphy Lake Boulevard. Just one question I have is, can I get a copy of that presentation that that Mess and Brings planner put up? I know you can't. Can you just email that to me or something? Or just give it to me? Okay. And then the other thing I just wanted to mention is, if, I don't even know if this is the right public hearing or if I should be talking about this during the plating public hearing, but I just want to make sure that if all these properties that are asking to be zoned commercial, that they get put under the same guidelines as the new platted area gets put under, in terms of respecting your neighbors and how your businesses look, and having fencing, having appropriate lighting, all those things that are going to have to be considered for the new development. I'd like to see these existing properties that if they get approved commercially, that they have to follow those same guidelines. That's it. Thank you.
Don't forget to fill out and I see the next person coming up.
Hey guys, my name is Robin Fox. I live on Killarney Avenue, cul-de-sac. My house would be directly affected by what's going on there. When we built that house in 2012, I spoke with the county and they said that 2030 was what was that's when things are gonna move forward with residential. They never mentioned anything about industrial. Now, if they would have done that, I wouldn't have built my house there, for sure. This is going to majorly affect me and my property value. It's probably going to affect everybody else too. But I just need to know like what is going to be built there. How is it going to affect my view in my backyard? I think it's just really, really sad for me to think about. Yeah, basically I wrote down, basically, I want to know what's going back there. I know you guys probably don't know for sure yet, but I mean, don't we have enough storage facilities in this area? I mean, I know that's what they're talking about. I went back there to try and talk to one of the planners back there, and he said, I don't have time to talk to you right now. He's very rude to me. And I said, hey, I live right here. It's a direct influence on my property. I want to know. And he just basically told me that they were going to be putting office buildings up and storage units and all this other stuff. And I don't think I'm opposed to that 100%. I mean, let's see what else do I have here. Yeah, basically I want to know where they're going to access the field behind my house. But I mean, that's all stuff that's going to be talked about, I'm sure, but I'm opposed.
Thank you.
What was your address again? Mr. Fox?
Pardon me?
What was your address again?
17491 Killarney Avenue.
Is there anyone else who'd like to get up and speak?
Dave Dillon, 7455 180th Street East. This is just all coming up fast, and sounds like it's a little bit of a boondoggle. I'm concerned about water use. I'm concerned about industrial with hazardous materials, oils, chems, and I'm not a liberal. But getting in the water, and how much water is that going to use? Where are they going to get it from? How much water? Is it water intensive industry? The storage, I'm very concerned about putting up barriers. I know in other towns, you get a business in that's a bad neighbor. I'm not saying Mess and Brink is, never met the guy, don't know anything, but I'm just saying as a concerned citizen from what I've seen, some of them are eyesores, and it's a hell of a problem to try and get stuff straightened out. You really need your ducks in a row before you do things. I understand if you put a septic in that it's approved before you hook up on public utilities, I haven't heard nothing about public utilities coming out here. All my neighbors were on our own wells and septic and how that can affect the wells. Mine's a pretty shallow well. And I've worked on a lot of big construction projects, golf courses, bear path, different things. And I see them D8 dozers going, and I got a quad axle in the ground if it's the right play. D8 pushes back, it actually lifts my truck up in the clay on the ground, looks like liquid waves. And I don't know what's under there, or, you know, there's just a lot of things to do, and I just hope it all works out good. And because we just don't hear anything, and it's nice to be able to put stuff in, and I'm glad we were able to express our concerns. And I thank you all very much.
Thank you. Please be sure to sign this sheet. All right. Is there anyone else who wishes to speak?
Sign afterwards. My name is William Russell. I have to look at my address because I haven't built on the property yet, unfortunately due to health concerns that have kind of propped up, but kind of waited until we hear things like this before we decide what to do. But we're at 17438 Murphy Lake Boulevard. We're basically adjacent across the street from part of what's being recommended. If you go back to March of 2022 and you look in the YouTube channel, right, we've kind of put together a puzzle piece where I think Mr. Mesenbrink wanted to build on his property there. And all of a sudden we built some puzzle pieces now to get a significant amount more in commercial, which, well, I'm not against the commercial, I am against this amendment because you do have such a scope creep that you're looking at from one place to the next without really a plan for what's going to be done with those properties. I don't share the same concern with some of my neighbors that live there, and that this is going to be a 4-story apartments and this would be better. That's like way down the line past my lifetime and beyond. I'm just not concerned about that. But when you look at this, you know, this parcel that keeps going, you've got already part in the comprehensive plan where you got part of it already zoned commercial. We haven't even started on that, right? And then we're talking about zoning the other commercial. We don't really know what it is. You know, is it going to be storage units? Talk about, you know, damages. We haven't even identified what was going to be built there, right? So there's no real plan for that. So it's, you know, without that type of plan, which you guys are responsible for making recommendations, like how do you go forward and say, yeah, we're going to be commercial? So I think there's a lot of problematic things and scope creep. And I will say one thing, because we haven't built on it yet, and we bought it knowing what that comprehensive plan was, knowing that there always can be some changes to the plan, get it. But, you know, now if there's going to be changes to that, we might build something different. And we might ask for the same consideration and ask for our corner piece, which is right across from Hannerhan, which is 300 feet from Mr. Mesbrick's property, where you start looking at that. I might ask for the same consideration. You know, that, hey, let's make mine commercial then. Valuable corner lot. So you end up having scope creep. Maybe you don't want that. But if you do pass it, I may ask for that consideration because what do I want to build on there now? So I didn't get to go through all 275 pages. There's a lot here. But I did read through most of it, and I looked at kind of the attorney's response to some of the damages, and they, you know, tell you to ignore some of that. I think good advice is like, what's the job you have at hand, right? Not react to some of the threats. So again, I'm stating that I am against it as written, but if it does go through, I may be back up here asking the same thing for my property. And I am the one that submitted something in writing, so. Thank you.
Thank you. Please sign. Is there anyone else who wishes to speak?
Hi, my name is Jim Schlimmer. My address is 7512 175th Street East. If If you take 175th down where it goes to the little loop, mine isn't one of the 3 driveways that comes off there. You'd have to go past my neighbor's driveway to get to this particular property. However, more than half of my south property border will touch this new area that hasn't been developed at all. And every house across the street from me would be rezoned to whatever this new zoning is rather than residential. It would greatly affect me, maybe more than Mr. Fox even, because his property will touch the new development. But I'm going to watch all these residential houses there. I don't think Paul Doles is here, is he? He owns at least 2 of those lots. Mark Suarez owns one. And I'm guessing there's already been a deal made to purchase those out because that'll connect his Mr. Messenbrink's current property all the way up to the new one. And I'm going to be looking at all industrial development across from my house. If I had any idea that was ever going to happen, I wouldn't have bought my house there either. I really am not against development out here. I think on 185th Street, Eagle Creek might be a good place for development, but to bring industrial right up to my yard, I think is asking a bit much of us and opens up a big can of worms. I have no idea what they're going to put there. I may not even need outdoor lights if they're going to have all the parking lots lit up. And I'd much rather see apartments in there than a big industrial storage unit with bright lights right in my bedroom window every night. So this has all kind of been shoved at us. I really hope you consider all this, that I may just be one house over there. But I'm speaking for a lot of Credit River that all this stuff going on and encroaching on us is just happening really fast. Thank you.
Is there anyone else who wishes to speak?
Hi, my name's Michael DeLong. I live on 17150 Johanna Drive, so I'm not physically as close to the development as probably a lot of the people here. But just a couple of thoughts. I think just like the gentleman just mentioned, a lot of this does seem to be happening pretty fast. My wife and I, we moved 2 years ago this summer. We moved from busy area, much closer to the city. We came to Credit River for quiet. Excuse me, for quiet, for just the peaceful way of life out here. So a couple of the things I just wanted to kind of put at the commission just to think about. I'm not necessarily for all this. I'm not necessarily against all of this, but I want us to think about, what do we want Credit River to be, right? There's the immediate, what is maybe happening in the next 5-10 years. Let's think longer, right? I'd be curious to know of the 5,000 plus residents, how many people are 2nd, 3rd, 4th generation that have lived here for a long time? What do we want our city to look like, in 20, 30 years? I do also share a little bit of the concerns with some of the environmental issues. It seems like a massive misuse of resources to dig well, to build septic. Part of when we moved into our house, we had to completely have a redone septic system. The septic mound in the back takes up almost half of our backyard. That's right. That's the county code. That's how it is. That's all right. What is it going to be for large commercial and industrial? Again, what are some of those effects? So I think that's something we should definitely kind of consider and take a look at. I also understand as a property owner, owners have maybe certain rights and freedoms. I think it also is important that we kind of dance carefully with that, so we're not infringing unjustly on landowners' rights. But we are the city of Credit River, and yeah, I think our lawyer kind of emphasized, right, there's a responsibility to do the right thing for the city. So I don't want us to be, as a city, bullied by someone else that comes in and says, I'm going to develop 139 acres. That's huge, by the way. That's a massive amount of land. And we don't know everything that's going to be done with it. That just doesn't seem like the greatest way to make friends, but what do I know? So I just want to encourage the commission, think about, what do we want this city to be today? What do we want it to be in 20 years, 50 years? Some of these decisions will play along with that. Thank you.
Please come forward.
My name is Claire Holderly. I live at 19685 Oak Grove Avenue. I've lived in Credit River for 9 years and I love living here. My comments, I'm concerned with all the applications presented this evening and my comments are regarding all 3 of them. Do these types of businesses really create more meaningful jobs? Probably not. Do these types of businesses really pay more in taxes than a beautiful residential home? And have studies been done to show that there is an increase in tax revenue? Probably not. Will the commercial and industrial designations make any favorable dent in the increased density pressures for the city? Probably not. Is this type of application consistent with the newly created city mission and vision statements that will soon be voted on by the city council? Probably not. Do we really need a gas station that pays a lower wage with an already great option down the road called Quick Trip? Probably not. Would an industrial park be a great visual that says, welcome to the beautiful Credit River along 21? Probably not. Has the applicant complied with all the conditions of his conditional use permit throughout the years? I believe not. The city has not had the resources to do anything about it. So if we look at his history, then why would we believe all conditions on a much larger scale would be followed going forward? The 2 citywide resident surveys overwhelmingly show that residents value and want to preserve the rural character of our community. As such, any decisions related to zoning amendments should reflect and respect this priority. I encourage you to vote no on all 3 applications.
Is there anyone else who would like to speak?
Good evening. My name is Anil Seegat. I live on 165th Street East, 7917. What I would like to bring to your attention is an observation I made reading the 2040 comp plan. The comp plan designates this area where the proposed new development is being envisaged as urban expansion reserve post 2040. It does not say that we have to change zoning now until 2040. The current zoning, as designated in the 2040 plan, as I read it, is not urban expansion reserve. That comes into effect post 2040, and it's clearly mentioned in the letter of comments and recommendations that the Met Council issued to the city, I believe in 2020, and I sent a copy to the 2 council members and a planner about this just a few days ago. So I would suggest and hope that the Planning Commission takes that into account and takes into account that we should be in no rush until we actually pay attention to what the city residents want, do a master plan for the city so that everybody is very clear as to what kind of developments the city wants to go where. And if this area that's being proposed for a zoning change ends up being commercial, in a commercial area that the city wants, so be it. But I don't think we have done enough homework and reviewed precisely what the 2040 plan is asking us to do. They are telling the city to sit down and think about how we want the zoning changes to take place. And we have until 2040 to do that. That's what I want to say. Thank you.
Thank you. Please make sure you sign the sign-in sheet. Is there anyone else who would like to speak this evening?
No.
Thank you.
Hi, Shannon Sauter. I'm at 18091 Cleary Lake Court, so right off of 180th Street. So we'll butt up to sections 8 and 9 on that proposal. My biggest concern is that we've been in our house for 5 years and we're raising 3 small kids on a quiet cul-de-sac with land. And any development, from what I could understand, it doesn't look like that will go through. It looks like it would be a cul-de-sac there at 180th, but any through road to that would present a lot of safety concerns, I think, for my kids being able to ride their bikes up and down the street, down the big hill, all of that. So I have a big concern about any through traffic from there. In addition to the concerns about traffic, off of 27 turning onto 180th every single day, I'm worried somebody's going to rear end as I'm trying to take that left turn, because 27 is not built for great traffic turning left into any development. So large vehicles or more traffic going through 180th is a problem. Turning left off of 27 is a problem. And the only discussions that I heard were about the turns off of 21, which makes sense. And it looked like those had been reviewed, but I'm still not in favor of anything commercial with big vehicles and more traffic coming through that area. Additionally, and lastly, when there was construction going on 21 a couple summers ago, the amount of traffic that came down 180th Street, despite it saying no outlet, was unbelievable. There were so many cars that were coming down that street, speeding down, only to find out that they couldn't get through the cul-de-sac, and then speeding back up over that hill where you can't see over the crest. There's a bus stop at that crest. So that additional traffic is concerning. And lastly, then people would turn out of that cul-de-sac, just drive over the grass onto 21 and make their way. So I think that there's a lot more to be considered with that section of 180th and for our small little Cleary Lake development, and how that would be impacted by that section. So that's it.
Thank you. Is there anyone else who wishes to speak? Absolutely, sir.
My name's Ron Borgland. I live at 17571 Murphy Lake Boulevard. I'm not gonna necessarily say anything for or against. It's more of kind of on some lines about the flavor of Credit River. I'm a relatively new person living here, and I've been here for 28 years. The 2 properties across the road from me were occupied with their families since before Lincoln was assassinated. And they're still in the original line of the family. As for rushing to a decision, I think the input of the people of Credit River, which I know we have a lot of newer people, but I think the whole thing is the people of Credit River, what they want is the heavyweight on the decision making, not the lightweight. So the influence of you, the input you get from the community is lighter than what is actually out there. If you're following what I mean, not too many people are anxious to get up and speak. So the point or the pick of the iceberg is what you're hearing of maybe a larger swell. So I think your thought pattern should be weighing towards the citizens of Credit River and how they feel. Now, we all need commercial space someplace. Things that we need from commercial don't just come out of thin air, but actually how it's developed and where it's, I mean, since I've been out here, Don Lear's property has been commercial for 28 years, you know, and nothing's been done on about 90% of it. So, pretty much kind of sums up what I was going to say. And One thing I have to say as a person who's been here for 28 years, I miss the old town board, not the city.
Is there anyone else who wishes to speak this evening on this first item? Is there anyone else wishing to speak? Okay. Is there anyone else who wishes to get up and speak? If not, Planner Strickler, would you read the written comments that we have received?
Yes, I will read. Okay, some of them don't have addresses. But okay. All right, so one resident wrote in that said that they're writing this afternoon in opposition to the current amendment for the land use proposal, that they've lived in the city for over 40 years and chose to stay because of the quiet rural setting. They live close to the proposed land amendment change and can confidently speak on behalf of their neighbors that they love the quiet tranquility of Credit River and do not want to see proposed commercial and industrial properties disrupt peacefulness. That's why they live where they do. If we wanted to live in an area where there was more commercial and industrial, they'd move closer to the metro. And that they understand that with commercial and industrial comes a larger tax base, but is confused as to why the city needs a larger tax base. And maybe spending should be controlled first. And that they are, in conclusion, adamantly opposed to this development. I'm gonna do shorter ones first. Another resident submitted one that's pretty simple. Him and his wife have lived in Credit River for many years. The neighbors and them are opposed to any kind of rezoning to industrial. No gas stations either, and leave Credit River alone. Another resident sent in 2 questions for tonight. One was with regard to the comp plan amendment. Would the zoning change go into effect immediately, even though most of the properties are residential with people living there, or would it be a future change? The second question is regarding the request. Oh, this is the plat, so I'll read that during the plat public hearing. Resident that lives off of 180th Street asked 3 questions. 1, why would the planning commission believe that moving these specific parcels from urban reserve to industrial commercial be a preferred long-term solution for the future of Credit River if they choose to accept the application? While I understand the need for commercial and industrial parcels within our city, specifically, why would the commission believe this location is best suited for those uses now? Is this application premature? And will this have negative impact on logical future development in the city? Second question is about the rezoning. So I will read that during that public hearing. And same with the next one. Sorry, with that response. Okay. Another letter from residents that also live off of 180th Street. Submitted that they are concerned with the existing noise that's already occurring near their property from the county roads, and that this would be an addition to that with the increase of commercial traffic right across from the street. And they also have concerns that building commercial buildings would increase crime and traffic, or I already said traffic, but crime, and that there's already an overflow of traffic. And then the third concern is environmental of nature with the existing wetlands and trees on the property that do provide a bit of a noise barrier at this time, as well as existing wildlife that currently runs through the property that they are concerned what will happen with all of that with this. And then the final written response that we received is also another resident off of 180th that is concerned about noise, traffic, road maintenance, if the proposed development were to extend onto 180th, it's an older road. It's not necessarily in the most mint condition at this time. So any improvements or anything like that, who would be responsible for that maintenance and then pay upkeep for it? And then lighting, that concern that this type of development or land use change would add an increase to lighting and contribute to light pollution, which is something they like about Credit River that there isn't much right now. Those are the main concerns in that one. So that's what I have printed off.
Thank you. Given that we have no other residents here tonight for public comment on this specific item 3.1, could I get a motion to close the public hearing?
I move that we close the public hearing.
I have a motion. Do I have a second?
I'll second.
All those in favor, please signify by saying aye. Aye. Motion carries. Do any of the planning commission members have questions, comments, concerns that they want to share or address regarding the application?
Well, I guess one thing if I had any questions, it'd be something directed at the builder, but he's not here, so I don't know. Are we just asking questions among ourselves then? Is that?
Council?
Chair Olson, Commissioner DeBrath. On this first application about the guiding, there is no requirement that the applicant build what they've presented in a concept. We're talking about guiding only.
Oh,
They've given you opportunities to consider what will come next as their plans are.
oh,
They're not required to do that. When you're looking at the guiding, you should be considering what is allowed under that guiding. And I can tell you, the way the plan is set up, commercial guiding will allow either a zoning amendment to commercial or a zoning amendment to industrial or some of each.
mhm.
And that's the level at which the decision-making really needs to happen.
Okay.
Thank you.
Thank you.
Commission members, what questions do you have?
I'll start, I guess. So this question is probably more for Pete. I think I kind of know the answer, but is there any way to, I think at the end of the day, just the 90 acres was always the kind of the goal to get switched. Is there any way that if the other property owners were interested in not being involved anymore, you could just do the 90 acres and not the smaller 10-acre ones, or two?
So Chair Olson, Commissioner Casey, if I understand the question, I'm going to say it back to you to make sure I'm tracking with you. The applicant has applied to re-guide 6 PIDs that totals 100+ acres. Could the planning commission approve something less than that? Is that the question?
Pretty much.
Yeah. Unless the applicant submits something to revise their application, you'll need to decide the application that's in front of you and all its scope.
Yeah, I've got a question, comment. As we look at this and look towards the growth of our future, I kind of feel a little bit of this is premature, and or would what kind of impact would that have on the infrastructure of expansion for future? You know, if this development were to move forward, and would that impact for future or concerns of that, would that all be in the pre-planning as far as for future septic, utilities and other stuff like that? And if it is an issue, who pays for that? Taxpayers or the developer, or, you know, that's kind of one thing to look at. And also you do have some obvious concerns with everybody want, you know, the community, and, you know, what's the what's the curb appeal of our city? How's it gonna look, you know, so if to go forward, we'd have to have some real strong parameters in with that and, you know, there's always a comment that's been brought up, Jennifer brought it up to be, compatible with neighbors. Well, and the other part is always talked about tax base. I think some studies have proven that residential tax base, if we're gonna really be looking at that, would have a better ROI for the city. But the concern with tax base too, that if there weren't defined parameters that, like the one gentleman, I believe Mr. Fox had mentioned that, you know, what impact would that do to all those properties to say the south? You know, what would it do to the values of that and the tax reevaluations on that? So something that comment or concern, I guess, that all looks I guess more hidden than not. I don't know, so just some of those parts I just feel like are a little bit premature. But you know, it's like, what's the best way to try to skin this cat or just so everyone is happy? You know, if you look at some of those plans too, where you know, on that road and feel the concern having young kids myself, with traffic, how do you really control that? And you know, these other property owners to the south and to that southwest corner, you know, is there a way to close it off? And have that as the pre-existing residential to keep it more residential. And then when we're pushing dirt, put a big ginormous berm around it of some sort. But yeah, I guess that's just the concern of that. It's a little bit premature and what concerns do we have for future development?
And as I'm looking at the criterion in which we need to make our decision, we really need to be referring, as I understand staff, to our comprehensive plan and framing in that sense, in terms of, is it consistent with the policy statements that are outlined in chapter 2 in particular? And I hear you saying some of the things without necessarily having directly connected that back. In terms of the, you know, the no guarantee as to how the, you know, tax base would substantially increase with our goal that growth and land use development be managed in a fiscally responsible manner, which will result in staging of infrastructure and investments to support growth. Could you walk us through a little bit more with how we should be framing it from the comp plan perspective too? And I want to hear all the questions and concerns, but I'm sensing that that might be helpful for us as we think through our decision or recommendation, I should say, to the council.
Absolutely. Chair Olson, I mean, you outlined it great in your initial analysis. Yes, what we're looking for here, and there are, you know, other elements within the staff report that, you know, are relevant to this future land use amendment, but particularly here, consistency with the goals and policies, or inconsistency, could be both. And as Attorney Michael pointed out, and I do in my report as well, there are some goals and policies within our city's comprehensive plan that are not necessarily super cohesive with each other. And that, you know, is okay to talk through and point out, but we want to make sure that any decisions that you're talking through today are talking about that consistency.
Madam Chair,
Yes.
if I may add to what Ms. Stickler has said, when the court remanded to review the comp plan, court referred to this as a self-imposed duty This is something we have to do because our comp plan says we have to do it. So that's the whole source of this.
Mm.
And the court said, it's not directing you just exactly how you do this. It's just that you have to do this. So wrestle with it as best you can, whether you tie to every specific point to elements of the plan. If
Okay.
those are the things you're thinking about, lawyers later will figure out whether they align the way they're supposed to align. And Mr. Perry and Mr. Kubitschek can fight about that in a place you don't need to worry about. Just have in mind what these policies and procedures, policies and goals are in the comp plan as you're wrestling with them. I believe promoting tax base is one of them. And so, you know, I would kind of automatically feel like you are wrestling with the things the court's asked you to wrestle with.
Okay. Thank you for that clarification. I find that very helpful. So as we're thinking through, what stands out and what questions or comments do each of you have, commission members?
Chairman Olson, I'm pretty much a nerd in this. I've copied out all these things, especially the comp plan, had this for a long time. And when you read through it, it has simple statements. And especially section C, pursue commercial and industrial development to diversify the local tax base and promote local employment opportunities. So, and then underneath that, there's promote new commercial and industrial uses where compatible with adjacent land uses and infrastructure. If necessary, land for future commercial and industrial uses should be reserved until urban services are extended to the area. I'll make some comment on that in a second. And then develop zoning standards that encourage high quality and aesthetically pleasing commercial buildings. Now, I guess with the one thing where they talk about the urban services, which is basically sewer, water, and then I guess also that includes infrastructure such as roads. And what the proposed development, they're not needing the sewer and water to come down. So that would not, as far as the urban services, that's not coming in, and that's been a big problem for a long time to tap into the resources that I guess are north of us. So at this point in time, the applicant has done several things to try to alleviate some of the issues that come into this as far as what we call being premature. Well, the services aren't there, but they're putting in their well and septic. And then there's some comments about that. And then high quality and aesthetically pleasing commercial buildings. I guess one of the questions would be, is that okay, since this is something that we can't talk about now, we're just talking about the guiding, as you're saying.
That's correct.
So then I'm just thinking, if the guiding was approved, what if? Then going on into the other areas, with this talking about aesthetically pleasing buildings, and we're talking about buffers and zones and setbacks for areas that are not consistently the same as what this is. That's what's going to try to address some of these things that a lot of the people are concerned about as far as where their properties are in relation to where this is. Is that something that then gets addressed by the planning commission and then to the city council on a ad hoc basis as it comes up?
Chair Olson, Commissioner DeBarath, Claire, you owe me a beer, first of all. Sorry. The comp plan is written to require you to review land use changes. And so it applies, that rule applies to comp plan amendments, which is high level legislation, zoning choices, which starts to narrow what, if you choose commercial guiding, you still have choices to make about what zoning. And then once you're there, and when you're doing that, you need to review these policies. Get to you've got the zone, then you get to the preliminary plat application, and you start to think about some of these things as well, although at that point, we're not talking about land use change, but rather an implementation. And as I think the commission is well aware, any preliminary plat application has to be consistent with the comp plan. So some of the things that you're wrestling with may be appropriate in the second or third application tonight, maybe a little bit more than the first. It's not a one size fits all. Every one of these is gonna fit just the same on each of these applications. And I'm sorry that makes it harder and maybe less clear, but
I think that, I guess in my thinking, I try to think of all the different steps going down and said, okay, this happens and okay, what happens next? What happens next? What happens next? And it sounds like at this point, I can't think of the what happens next. I have to just think of this part.
that's, if I may, Chair Olson, that's correct, because the decision that you're making now is only about guiding in the city.
Okay.
And guiding is a very high level. It can allow a lot of things to follow, depending on what change in guiding there is. Right now, the land is guided and zoned UER, which means it's 1/40. The table of uses in the code allows residential, agricultural, and some types of recreational uses that will take big kind of areas like that. That's the decision that was made when the comp plan was last passed. You have the authority to decide to recommend whether you're ready to move on from that, and if so, under what circumstances. But you're not committing to a specific project if you decide we'd like to expand commercial guiding. You don't have to go all the way down. Or if you want to consider the consequences, consider them as potentially broad consequences that will need to be narrowed with zoning decisions later.
Okay. And since this isn't the final word, if this does go forward. And
If you approve the guiding that's been requested, it's not the final word on what's going to be zoned or what's going to be built.
I get you.
It will have to be consistent with commercial something.
Right.
That's as much as you've decided at that point.
And I know that we've had talks about the vision statement, and we, as a new city, we are trying to advance things, and I know it's been kind of a slow pace. We do have a vision statement that has been hammered out. It hasn't been approved yet. And since we're right now going over business that happened basically 2023 is what we're basically talking about now. This had been before. So I guess what I'm thinking, and we're thinking of what was said, that we can't look at 23 with current of what's happening now. Is that?
Respectfully, I disagree with Mr. Perry. This is a legislative choice you can make. The standard is rational basis, broad discretion. The Supreme Court has twice said, let me put it this way, you're not deciding to make a new law tonight. The city's already made a comp plan. You're deciding whether you want to change what's already been adopted. You have a rational basis to decide. There hasn't been any changes that suggest to us that we want to change our comp plan. We didn't make a mistake in the comp plan. So you're free to not make a change. You're not required to do that. You are free to look at what's going on right now and decide, is commercial guiding in this area, which is next to some already commercially guided property, a thing that is a good idea for the city, and are we prepared to make that decision tonight? I prepared in the sense of, if I may borrow comments from one of the speakers, when you do your 2050 plan starting in a couple of years, there will be, the master plan is not quite the right word for this, but there will be planning and studying to figure out where things need to be. Do you have the information you need right now to know that the plan that was decided on in 2020, the 2040 plan, can be changed without unintended consequences? Is it a good plan? Is it obvious on its face, this is good, we love this, we're glad you came along? All of those are available to you. Just make a wise decision.
Yeah, it seems like we're we're working with what's been given to us here with this comp plan. And of course, everybody, we're all thinking of, okay, we want to make certain decisions, certain choices and certain planning for the future. But this is happening now. This is, I guess, we've had an application that someone has read this comp plan as well and have said, okay, I want to put in some commercial property. And they made efforts to find land where they could find it, and obviously that's where it's at. And I guess it's what they're wrestling with. And of course, it's the hard thing that we're all considering is it has effect to other people, property owners nearby. And I guess that's one thing that sticks in my mind with everything else. But then again, that's where, which as you're saying, we have then controls that we can put on later on after this fact that can alleviate some of that.
Chair Olson, Council, Commissioner Theobald, I'm really trying to stay around what the rules are and the boundaries. And not tell you what to do. Or have a voice on the merits. In terms of compatibility, and the applicant said something about this, every city that has a comp plan with different uses has to deal with the fact that they are going to have, they'll be adjacent, and you need to work on how to transition. And so transition is always possible, and it's always something that you could work on. And this is a complete hypothetical. It's not about this application, but if you were to have a desire to have a more commercial, and you knew there was a residential neighborhood nearby, you may decide that the kind of commercial that you liked was like neighborhood services rather than industrial. Or you might want the neighborhood services, then light industrial and heavy. You can work out all of that stuff at future stages. We have a really blunt instrument here of basically commercial or residential is essentially what you're looking at if you were to change UER, which is essentially a agricultural and commercial zone for now.
Okay.
All right, I got one. This is probably more for you, Claire or Steve. So goal A in our comp plan is growth and land use development shall be managed in a fiscally responsible manner, which will result in staging of infrastructure investment to support growth. And then under that, letter C is manage growth to maintain reasonable tax rates. Do we have any idea of how much tax revenue the commercial would generate versus if it would be residential, or is there a way to know that?
Excuse me, Commissioner Casey, we do not have a study for this particular property at this time for either residential or commercial. The city has done several studies for other parcels, but that wouldn't be relevant to this.
So I guess I got another question. And so for like our commercial tax rate, is it just, does it just go off property value, or how exactly is it figured, do you know?
Go ahead.
Chair Olson, Commissioner Casey, on the comp plan policy about tax rates, I think it's important to keep in mind that right now it's guided in zone UER, which is basically the lowest possible tax revenue. If you guide it commercial, I think you should recognize the differential between what's now and what commercial is, not what is commercial versus what might be residential in 20 or 50 years.
Sure.
You really should be looking at what they're proposing versus what the tax revenue is right now.
Sure.
Other questions? Comments?
I got another one. It kind of pertains to, so yeah, the comp plan is for like 2040. this is probably for Claire. So it's the 2040 comp plan. Is, how do I put this? How is that like supposed to be implemented? So it's like if somebody comes in, are you expected to just let it happen 15 years sooner, or how, you know what I'm trying to say?
I think so, and I'd be happy to, you can always ask me another question after my answer, but I think what you're asking here is, why do we plan for 20 years if things are maybe happening sooner?
Yeah, it's more, are we expected to do it before, even if it's not intended until 2040?
So I think it's important to understand that all well, not all, but most planning processes are a 20-year process with a tentative update every 10 years. That's where most communities, most counties, even if you weren't in the Met Council jurisdiction, that's planning best practices. A 20-year outlook, that's what we look at with future land use planning, et cetera. For the particular instance of planning sooner, I think that's really only partially relevant with the potential expansion of urban services. When you're looking at the land use policy as kind of outlined within your comprehensive plan goals and other sections of the city's ordinance, we're really looking at consistency with the goals and policies of the time when the application for an amendment might come forward, or like I said, the city will be looking at their future land use map for the 2050 plan in the next 2 to 3 years, likely, starting that process. So there really isn't necessarily a pre-2040 decision on a land use side of things. The 2040, the post-2040 that's discussed in our comprehensive plan, it's a lot more in line with some of the Met Council's policies that you as the city have to put in your plan and have to align with whatever that community designation is, which in this instance for the northern part of the community is diversified rural. So that's kind of, it's a little, I think that's sort of your question.
Chair Olson, Commissioner Casey, if I could add everything she said, which I thought was worth listening to, is the fact that there's a 2040 plan doesn't lock the city in. The city has all the discretion, if it chooses, to change some component of that plan in the interim. That's a relatively routine thing to do if the city is satisfied that it makes sense for the city. It's perfectly appropriate for the applicant to bring that application in now and for you to consider it now.
Sure.
Would you be able to talk about the difference between urban expansion reserve and diversified rural?
Yes. Yeah, so as I mentioned a little bit in my response to Commissioner Casey is that the Met Council of all of the metropolitan counties provides different classifications to all of those cities. Some of the cities have multiple within those, and for the 2040 plan, this northern part of Credit River was diversified rural, which there are other communities in the metro area with that designation from the Metropolitan Council. This is what is assigned, which is usually on the basis of existing development patterns, challenges shared and done again within that regional planning process. The Metropolitan Council just finished that up for the 2050 plan. So I think it is different for the northern part, but the adopted plan that we have in front of us this evening is diversified rural. And part of that designation is MUSA, or the Metropolitan Urban Services Area, the percentage of developable land that's committed to urban uses, the age of the housing stock and proxy for age of infrastructure, long-term wastewater service area, and then density. So that's in the essence that what the Met Council provided for that designation influences your future land use, because that is the city's designation that does have to align with those policies that from the system statements of the Met Council. So that's the big difference. One is Met Council designated, and then you have your future land use category that city, or at the time the township / county have done for this, designated that area for the future, in the future land use area map. Yeah.
Thank you. That's just helpful
Mhm.
background. Commissioners, what other questions, what other concerns do you have? Or comments, I should say. Any other questions or concerns, comments, thoughts that you want to share at this time about the item 3.1? I know this is a lot to take in and study.
Yeah, I mean, another part of it that makes it tricky is because, being that there is commercial property fairly close to there. But yeah, where do you draw the line? I guess it's kind of, it's tough.
As I'm looking through, I see, staff report and having read the comprehensive plan, there are parts that could, of this application that could be consistent with with the policy statements that are outlined in the comprehensive plan for 2040. And there are others that are not. And on the whole, what I am concerned about is what level of consistency do we need to reach in order to make a recommendation one way or another. I've taken in the comments and the questions that we've received from the community. And as I'm looking at the staff report, it's those inconsistencies that I am wrestling with in terms of how we make this decision.
The question is, how much has the applicant successfully fulfilled the items of the comprehensive plan that we're coming up with?
That's as I'm looking through though.
Chair Olson, Commissioner Theobald, so we can keep interjecting law into the commission.
We appreciate it.
This is not like an application for a preliminary plat or a CUP, where if the applicant checks the boxes, the city doesn't have discretion. This is legislating for the state. The fact that you have a comprehensive plan that has competing factors means you need to wrestle with those as part of your decision making. But I would encourage you not to count up how many boxes go this way and how many boxes go that way, set a threshold that the applicant must meet. That's not the appropriate lens for this. It really is wrestle with all of it and then decide if you think you would recommend to the city council that this guiding essentially expand the existing commercial guiding into this new area. Don't feel compelled to, don't feel compelled not to, don't treat it like the other type of applications you often see where if boxes are checked, then the answer is given to you. Unfortunately, answer we'll have to give it to you.
Understand.
Thank
Okay. Any other comments, any other questions? If not, are we ready to make a motion?
I will. Based on our findings, I would. And it is tough, but I'd like to make a motion to recommend. That the city council denies the application. For the comprehensive plan amendment, based upon the application being inconsistent. Nor does it align with the 2040 comprehensive plan.
Staff recommendation also would suggest adopting the staff report into the record and accepting the application, testimony, exhibits, and other evidence presented. Is that okay to add as well?
Yes.
Okay, so we have a motion to recommend to adopt the staff report into the record, accept the application, testimony, exhibits, and other evidence presented into the record, and recommend denial. Do I have a second? I will go ahead and second. All those in favor say aye. Aye. Those opposed?
Me.
It appears we have a split decision.
I think that was an aye.
That's an A.
An A?
I'm an A.
Oh,
Okay, so we had a recommendation, motion. It was 2-2. Please advise.
Two options. Procedurally, number one. If the chair is willing to entertain more discussion, you could allow another motion. From the side that prevailed. In this case, the side that prevailed was the nays. The motion failed for one of the majority, so if, and then discuss that and see if it might change a vote. Don't have to do that, but that's an option.
Okay,
The second would be to report effectively to the city council that you were split to 2-2. And I think it would be appropriate just to give the council as much guidance as the planning commission can offer. To offer the two commissioners who voted no on the motion to offer their reasons if they have any they'd like to articulate for the position that they've taken. So council has the benefit of their insights as well.
that makes sense to me. So ask for a different motion. Or ask for explanation.
It's the chair's privilege whether or not to allow another motion. If there was a motion and failed, you could be done and present to the council the split points of view. If you think there's a possibility that another motion might generate a consensus, that would be a reason to consider it. If it feels like that's not the way this feels, I would just suggest that the two who voted no have an opportunity to express to council their rationale.
I would entertain another motion.
Are we asking for a vote on another motion?
We would be asking for
Oh,
another
I thought
motion.
You would say we should have more discussion and then have another motion?
So, yeah, sorry, the Robert's Rules of Procedure are not fun. The way to have more discussion would be if one of you, it would have to be one of the two of you, Casey or Theberath makes a motion and gets a second, that would reopen discussion. You'd have to have a motion and a second to reopen the discussion.
Okay,
Chair's privilege whether to accept another motion at this time.
I would entertain a motion to reopen discussion.
All right, I'll make that motion.
Excuse me, I'm sorry, Chair Olson. The motion would need to be to recommend something to council, not to move for discussion.
Okay,
I'll make a motion to recommend the council to approve that we're, Is that the appropriate terminology?
That is the appropriate terminology, and as with the others, would you, as part of that motion, incorporate into the record the staff reports and
Yes.
so submittals?
Yeah, and then that would be contingent on Met Council's approval. I suppose?
All you're doing is making a recommendation to the city council. If the city council chooses to adopt an amendment to the comp plan, that would always be contingent on the Met Council's approval.
Okay.
So I have a motion. Do I have a second?
Second.
All those in favor, please signal. No,
Now discussion.
and now we have opportunity for discussion. Okay, so we'll reopen. Commissioners, what say you?
Start? Okay, I'll go ahead. In my opinion, of course, development is coming at us and the applicant has made a pretty good effort to follow the conditions that were set forth in our comprehensive plan. And I think that we would all like to wait for some better conditions, but how long does that happen? This is happening now. This is something that has come to us, ready or not. And I guess I wish we could be all better prepared or have better things, have vision statements and have this, but we don't have them. I don't know when those we can have all these nice things in place, even though the world is happening around us. And this was a active request for a commercial property in addition to Great River. And they did that all in good faith and follow the rules of our comp plan. And I think that I guess that it's whatever thoughts we may have, they did it all in good faith. And just to say, well, we have to wait until we've done some other things that haven't happened yet. They don't know that. Now I know that, we have had various developments come through too. And the reason those probably didn't go through is probably more economic, like with a couple of housing developments, and then of course there's another one maybe coming back online, I don't know. So I'm looking at that in kind of the other world, but as I'm looking at the application for a business and industrial, and we have it in our comp plan, promote new commercial and industrial uses where compatible. But the way we're laid out, where it's compatible in Credit River, it's going to butt up against something. And I guess what we're coming up with is that, okay, this is a separate thing as far as the guidance. Now, the things that we can do to work on compatibility with adjacent land and other homeowners and such, that could be happening later when we do the plots and then other approvals down the line. This is one part of it. So I guess the request, I thought that for the applicant to make this change, have a change to the comp plan, which our comp plan says that can be done. We need to follow our own writings here. That was just the way I kind of look at it.
Yeah, to me, the biggest part is, I know this is gonna kind of sound, it comes down to, well, kind of fairness, sort of, the being that, the property just across the road just got changed to commercial within the last 5 or 6 years. That's a big part of it. And then it's, I don't know, just private property rights and telling people what they can and cannot do with their property is, I don't know, a big piece of it within reason. There's rules and all that stuff, but I guess it's more not seeing, you know, that's my main reason, I guess. In my perfect world, it would remain a field, but that's not, yeah. So, yeah.
Well, I can respect that. I do see that the application is inconsistent with the policies that exist within the comprehensive plan. And for that reason, they're not across the board consistent or inconsistent, but there is enough inconsistency in terms of compatible use, in terms of, you know, as I'm looking at it, assuring that incompatible uses are not located close to one another. And I realize that some of these things can fit. However, I think there is enough inconsistency that this application gives me concern.
Likewise, and I agree with Commissioner Casey. I mean, you should be able to do whatever you want, right, with your land or have rights to it. But I look at this application and I see we're trying to follow this 2040. And we want to look at what the city's gonna look at. And quite frankly, I think a lot of citizens have spoken. And was anybody here to support it? You know, I look at that in my decision. There wasn't a single person to support it. I'm just doing what I've been appointed to and look at the facts in black and white. And thank God I'm not a council member, because I'm just trying to pass the buck on. But you know, I'm just looking at the whole picture. But yeah, I mean, I grew up on a farm, and boy, if somebody told me I couldn't do whatever I want, I mean, I do get that, and I have respect for everyone as well as Mr. Mesenbrink. And I'm just looking at this, and I just think it's a little premature, based on where we sit, and following the guidelines that we've been told to follow. It's the 2040 comp plan is kind of like a little mini city Bible, you know, and that's where my decision falls, where it is.
At this time, is it appropriate then to ask for a vote on the motion?
If there's no further discussion, she calls vote.
Is there any further discussion? Seeing no further discussion, then I would, all those in favor of the motion, please signify by saying aye.
What motion are we? Oh, his motion. Okay.
All those in favor, please signify by saying aye.
Aye.
All those opposed? Nay. So at this point, we remain split.
Let's leave this on. So at this point, commissioners, the city planner will draft a report for the council when it comes to council, indicating that there is no resolution coming out of the planning commission for want of a consensus, and reporting summarizing the positions on both sides of the question.
Okay.
And that should conclude that item and be ready to move on.
Okay. With that, item 3.2 is next on our agenda. Our next public hearing is on a request for zoning application amendment for property identification 049080030 from urban expansion reserved to industrial commercial. Planning Commission members have received the following documents: the MSA staff report regarding the rezone request, and Credit River narrative for rezoning and preliminary plat, Mesenbrink. City staff, before I open the public hearing and ask the applicants to come forward, I'd like you to summarize the application and offer relevant background.
Thank you. Thank you, Chair Olson. I'm just scrolling through our massive packet. We write page numbers. Excuse me. Okay. page 99 of your packet, 100 of your packet. Okay. So the application for agenda item 3.2 is a request for a zoning amendment or rezone to change PID 04908030 from urban expansion reserve to commercial and industrial. The preliminary plat application was submitted concurrently, and I'm just pointing that out because that shows the breakdown of these 11 lots. 2 are proposed for commercial, 9 are proposed for industrial, and there is a breakdown of that layout and where the industrial and commercial would lay on page 101 of your full packet and page 2 of 6 of the MSA staff report. Let's see. Proposed building footprints, yeah, just concepts at this time. So at this time, we're just looking at zoning from urban expansion reserve to commercial on 2 parcels and urban expansion reserve to industrial on the remaining 9. The city code specifies 5 criteria that a zoning amendment should be evaluated for. The applicant did provide an analysis in their submittal materials as well as city staff did within the planning staff report. So that's my general overview of this application.
Thank you very much. Would the applicant care to come up and make comments, please? Thank you.
Good evening again.
Good evening.
Thank you for all of your good discussion on the first agenda item. You'll be relieved to know that I don't have a presentation for the second agenda item. But what I will say is Ms. Strickler has identified our request this evening accurately. Obviously, the intent was to do a mix of uses. And that is why we've identified both zoning districts as applicable to this particular area. We do anticipate just based on who we've talked to in the marketplace, that those zoning districts would support the types of users we've been in discussions with. So I have nothing else, but happy to answer any questions you might have.
Are there any questions from the planning commission members at this time?
Again, Jack Perry from Taft Law Firm. My only comment is I think one of the things that we agree on, and I'm not trying to put words in your mouth, counsel, but I think we agree that if this side of the room's recommendation for approval is approved, then it'd be hard to say no to this request. Conversely, if this side of the room is correct, then it would be hard to say yes on this one. So I think there's a direct correlation.
Council?
I just can't get myself to agree with 100% of what you said, Jack.
Shocking.
If the council approves the comp plan amendment, the city must rezone. It has to rezone commercial or industrial or a mix. It does not have to do exactly the one that they have proposed, but the city will have to do something.
I think you said it better than you were more specific. So I'll take that as a friendly amendment. But the point is, we don't need to belabor this one. Is the domino theory? I think we're in agreement on that.
Okay. All right. With comments from the applicant, we'll now open the public hearing. Again, this is your opportunity as residents to make a statement and ask questions on this application. If you would please step forward and introduce yourself and then fill out the sign-in form, that would be appreciated. Are there questions or comments from the public on this application?
I'll go in. I already signed up, baby.
I guess my comment to the board would be in a question that if this passes and there are things that are going to be put in place as far as berms and stuff, would you be doing that for high density development also? Is it setting a precedent? What does that look like? We don't have any ordinances right now about that. Also, again, I just want to emphasize the density that will be required by the Met Council. And if we, some gentleman said before, is it going to be scope creep where we're going to have more and more commercial? Then where does the housing density, where is that going to be? So that's my concern and my comment. And I know that Jennifer has worked for Met Council, and I don't know if we can ask or not. And my question is just related to that. Okay. So that's something again to think about. Scope creep, commercial. Where does that push the density? Where do we want it? Again, the vision of Credit River. So I thank you, gentlemen, Amy, for thinking big picture. That's it.
Thank you. Is there anyone else wishing to get up and speak? Is there any other person here wishing to address this matter? Seeing none, can I get a motion to close the public hearing?
Move that we close the public hearing.
I have a motion. Do I have a second?
I'll second.
All those in favor, please signify by saying aye.
Aye.
Aye. Anyone opposed? Motion carries. All right, planning commission members, this is the opportunity for you to ask questions, comments, offer concerns.
I can start, I don't know if Steve, if you would know this answer or not, is industrial taxed at the same rate as commercial, or one higher than the other?
Carol Olson?
Yes.
If I may, particularly because it was a split decision before, for your evaluation of this zoning amendment application, you should proceed under the assumption that the council would have approved the guiding. Otherwise, we would never reach this question.
Okay.
So understanding for the sake of argument that this is guided commercial, how do you view this amendment application? And in terms of consistency with the comp plan, this is consistent. It's zoning and it's industrial, which would be consistent with commercial.
Okay. Because it's existing commercial and it's being rezoned to industrial.
No, because we're only looking at this under the hypothetical case, which may or may not become true,
Got
that
it.
it's been guided commercial. And so what they've applied for zoning wise is consistent with commercial guiding.
Well,
Okay.
well, correct me if I'm wrong, isn't, so lot 5 and 6 is commercial and the rest is industrial, right? That's what we're, yeah.
Under the comp plan, the land use chapter, it doesn't have separate guiding for commercial and industrial. It just commercial, which means both.
Okay.
Okay. All right. Are there comments, questions?
The one item that looking at is that one of the concerns I had in the whole thing was that the I think it's 175th Street and 180th would, because those are not zoned handle commercial traffic, would that become a financial burden on the city as far as trying to improve those to take this property? I think if I'm looking at the on page 3 of their proposal, their zoning amendment, and I think I saw this in their And also within here, they talk about the business park will develop screening and buffering of future residential areas, making residential more desirable as the surrounding areas urbanizes. So they're, sounds like they're taking some action with that. Back to my part about the streets, it looked like the applicant had worked with Scott County to get a design where they'll, both sections, I guess, on either side of County Road 21 will have a access point right there. I guess they're almost across from each other. So they are not going to be going to from what I'm looking at as far as this proposed plan, they're not going to be going on to 175th or 180th. They'll be having access directly just to County Road 21. And I guess is that.
Chair Olson, Commissioner Thierer, if I may interrupt again, I'm sorry for all the interruptions. This zoning amendment application is again a legislative decision.
Okay.
We're not deciding the preliminary plat at this time.
Okay.
And so, and by the way, where I said it's consistent with the comp plan in the big picture, like Mr. Perry and I were talking about, just assume that it is. There are other factors in the comp plan that you look at. For example, these transitions and streets and things like that. That's all useful at, now we're kind of mid-level. We haven't gotten down on the ground yet. If you approve this zoning amendment, the applicant is under no obligation to proceed with the preliminary plat. So obviously we expect them to, but we're not evaluating preliminary plat right now.
Okay. That's the next one.
That's the next.
That's the next one.
So these are in that specific order.
So the policy question for the city, this is legislative now, is if you're gonna be commercial guiding, do you want, and I'm looking at the picture that was from the applicant's proposal of a concept. Do you want it to be commercial? Do you want it to be industrial? These are policy questions. And do you want how much of a mix of the two? Those are the kinds of questions that are legislative to be made now. And again, it's not like the preliminary plat next where they've checked all the boxes, and so we don't have discretion. Broad discretion for the city to decide. Assuming it's commercial, what kind of commercial do you want?
Starting to understand. Okay.
I appreciate it.
So would this be the appropriate time to talk about like outside storage and all that kind of stuff?
Yes, this is a perfect time to consider what the table of uses would indicate is allowed in industrial versus commercial, and what you think is appropriate where.
Okay.
It's gotta be one or the other or a mix. This is the heavy lifting actually.
Right, so it looks like the applicant has agreed to no outside storage on the south side of 21, which is good, because I think aesthetically that would be much nicer.
I'm sorry, I hate to keep interrupting. If we enact a text amendment to the zoning code and the zoning map to make these like this, we don't attach in our ordinances promises from an applicant.
Sure.
It just is the table of uses are allowed.
Yeah.
We get to promises when we're looking at preliminary plat and we talk about what might be in a development agreement as a condition of approval.
Sure.
We're not at that level yet. I'm sorry, it's so confusing.
So it's all or none, basically.
I think this is the first time where we've considered all three in one fell swoop. And so we appreciate the explanations because this is more complicated than perhaps we have seen.
It's a complicated.
So.
Yeah, I owe you a beer.
I will take you up, we'll get Leroy and we'll.
Got it.
How about that? Absolutely.
All right. Questions, comments?
And some of my questions kind of almost go to the next.
Okay,
We can't skip this step, unfortunately. We'll made a recommendation for council about this one.
all right.
And if I could make it a little bit simpler, famous last words. Legislatively, the city needs to decide what kind of commercial, but the only thing you need to decide is what they've applied for it. It's that, or maybe it's something else. It's that, or it's something, but that's kind of the fork in the road that the city needs to take on this application.
Okay,
If this application were denied, then in short order, it's not like immediate, but in short order, the city will have to come forward with another way of rezoning this property.
okay. So from that perspective, when we entertain a motion, since we were split on our recommendation to the council, how should we frame that up?
I would suggest the motion be framed. Assuming the council were to approve the comp plan amendment, then we would recommend you either approve or deny the zoning amendment application. But please pick one of those two. Approve or deny. Don't give them.
Okay. Do I have a motion if there are no other questions or comments?
How do they say that again? Assuming council approves the previous motion,
Assuming the council were to approve re-guiding this to commercial, then we recommend whatever it is you choose to recommend.
Are there any other comments, questions? If not, can I get a motion?
assuming that the council approves the regrading.
Re-guiding.
Re-guiding, sorry, re-guiding. This parcel, I recommend approval of the application.
I will second that.
Okay, we have a motion, we have a second. All those in favor signify by saying aye. Anyone opposed? Motion carries. Now we'll move on to item 3.3, preliminary plat for Credit River Business Park. Planning Commission members have received the staff report from the City of Credit River dated April 10th, 2025. Staff report from Shane Nelson, Hakinson Anderson dated April 10th, 2025. Comment memo from Mary Von Eschen, Scott County Environmental Services dated April 11th, 2025. Comment memo from Terry Dill, Scott County Highway Department dated April 11th, 2025. Applicant narrative, site plan exhibit, preliminary plat, preliminary plan set, and traffic study. Before I open the public hearing, I'd like city staff to summarize the application and offer any relevant background.
Thank you, Chair Olson. Tonight for your third and final application and public hearing, we have a preliminary plat application for PID 0490800030. This is an application to subdivide subject property into 11 lots, 11 lot business park. Each lot will be developed and improved with a custom building, potential accessory uses to meet the needs of future businesses. The applicant will install and construct all common improvements to the subdivisions, including roadways, private community well, stormwater infrastructure, future utility extensions located within the right of way. And as based on that summary, there are proposed public infrastructure improvements included as part of that applicant's request. Most of those specifically outlined in City Engineer Nelson's memo and Terry Dill from Scott County Highway Department, emphasizing some of the turn lanes and other comments that the county had as part of this application. And Engineer Nelson goes further into review on some of the proposed new roads, as well as other utility comments that he provided for your information.
Mhm.
The land use is proposed, like I said, for a combination of commercial and industrial uses. And in terms of if those move forward with the rezoning process of the council, the plat does meet all of those minimum district requirements for commercial and industrial for lot size, coverage limits, et cetera. And of course, once any sort of buildings are submitted and ready, that goes through the city planning and building review process. So
Yes.
that's what I have.
Okay. Would the applicant care to come up and present?
For the third time, Jack Perry from the Taft Law Firm. I want to make two comments, I believe, first is from the staff report. I know your council and I have gone back and forth to make sure that we're expressing agreement when we have agreement and disagreement when we have it. I think on this one, hypothetically, if you approve the comp plan, number one, and you approve of the rezoning, then I think we are in accord based on page 2 of the staff report, where it states if the rezone request is approved by the city, the plat meets minimum district standard requirements for commercial industrial lot sizes and coverage limits, blah, blah, blah. I don't think this is a disagreement. If the first step is satisfied, second step, we've satisfied. More importantly, some cities like to have all three these things together, because then you're not stuck in the question. Commissioner Thebreth, okay, you've asked several questions, and several people in the audience have asked questions about the details of this stuff, and particularly about berming and screening, lights, all that stuff. And I don't know if we made the right calculation or not, but it was my advice, Jennifer's advice, and the client's experience that in order to ask for step 1, the plan amendment, step 2, the rezoning, it was unfair to you not to see what it is and to also make sure that everyone knows, we want to screen. We do not have a national entity coming in, which is oftentimes a problem. We have a local person, in this entire family, entire compound, they're all together. They do not want to unnecessarily upset neighbors. They want to do things the right way. So that's all proposed in here. There's berming, there's the street designs have been worked out with Scott County. Doesn't mean that things can't change, but we wanted to make sure everyone knows that we get to stage 3, we've done things the right way. And we can also give you the addresses of multiple other sites that have been developed by Messenbrink Construction, so you can look at it. Not that things won't be, not gonna be identical, but you can at least get an idea of the quality that he uses. That's all I have.
Thank you very much.
Unless your council disagrees with me. Or
Any clarification, Council?
Chair Olson, I am happy for the first and probably last time to agree with Jack. If the guiding is approved, if the zoning is approved, and if, as Ms. Stickler reports, this meets all of our standards, this needs to be approved. It can be subject to reasonable conditions. We can work out things in the final plat stage with the development agreement about what the final approved plans will be and all that stuff. But this is relatively straightforward.
Okay. At this stage, are there any questions from Planning Commission members? If not, we will open the public hearing. This is your time as residents to provide comments pertaining to the application. And I would ask, do we have any specific to the written comments that we would want to tackle first?
Yes, I'm happy to do that first. Yeah, we have one comment with a question about the request to plat the 90 acres, wondering what the process for planning and setting guidelines for the developers and future owners of the parcels, giving consideration to surrounding home and property owners is. And then a second question, asking about moving forward with the preliminary plat and understanding that, sorry. Okay, moving forward with the preliminary plat, looking at the developer owner and his intent and business model. This seems the storage shed that this resident thinks is its only form of development. It seems to be the newest hot button topic. And that the sheds will provide business opportunities for Credit River. However, similar class projects within the area advertise as man caves, car storage, and boat storage. What kind of jobs does this really generate? And does Credit River want to start out as a storage developer? And those are the two written ones that pertain more to the plat application.
Okay. Is there anyone wishing to come up and speak on? No need to fill out the form again, but please introduce yourself for the record.
Okay, yeah, Shannon Sauter again on Cleary Lake Court. I guess I have a couple of things with regard to the previous conversations that we had specifically about your discussion with that. This is happening in the here and now, and this application was submitted and we have to give it honor. And I also agree with that. People should be able to do what they want with their land. However, there's no reason for you to rush into making a decision just because it's happening here and now and because it's on the table. I don't think that there's anything wrong with saying we might consider it in the future. It's not the right time right now. We don't even have our mission statement voted on. Like, we need to get some other things in place, and we appreciate your application and we need to take time to consider it. And it's not going anywhere. And if their business is that important, they can find another place. Additionally, what can be done to undo it? If, say, with the 2050 plan, we look down the road and we're like, oh, shoot, we wish that we wouldn't have started that with the north end, and we really want these particular things to happen in the south end. Can we undo it? Can we go back? Can we fix it? Or are we stuck with that being what's our northern end of our city? Should we decide to change it? And then my last point is with regard to, I think that the attorney had said that they're not obligated to follow through on the proposed things. And I did look through all 275 pages of it. And if this is going to go through, for my personal impact, there is that border at 180th that has the berm, and there appear to be trees and things like that. However, and I think that many people in the Credit River that are affected by this are not confident in Mesenbrink's ability to follow through on what he proposes. I think that he will suggest this beautiful plan that looks really good. And then judging by the way that it is on 175th and judging by images that I got of his property in Newmarket from the mayor of Credit River, I'm not confident that he won't change his plans or things won't slip or it won't become a dump. So I would like to consider, or have you consider, holding your ground and making the best choices for our city, not because it seems like we should do it now and not because he's throwing out threats or whatever have you, because we, the people that live right there and are going to be impacted, as well as the city, you know, as a whole, we deserve better than that.
Thank you.
Hello again, Tina Mishka. I guess my thoughts, comments again are the vision. So many people have talked about that. I've talked about that for years and advocated towards a plan, a vision for our new city. And it's just concerning if we are making these big decisions without a vision and without a plan, I think that's wrong. So I don't know the timeline about when that would be approved, but I think we need to consider that. Also, thought about the berms and everything. My understanding is with developers for residential, they're required in some cities to have berms and put up trees. But then when those trees die, they're not on the hook anymore because they're gone, they're out, they've done what they needed to do. So I don't doubt that John is Mesenbrink trying to work with the city, but I don't know whose responsibility that would be if those trees die, and maybe that's nothing to think about, but I think it's important, especially for those residents that live near those places. So think about the vision, think about the little details, the big details, and again, I don't envy where you sit. Thank you.
Is there anybody else who would like to make a comment?
I just wanted to follow up on what I said, is that if all of the people that are requesting this land zoning change get approved, I think that they should have to follow certain guidelines that they are not currently following at all. And it should these berms and all these things you're talking about, that should be considered for all of those properties, not just this 90 acres that he's talking about new development on. But I mean, there's existing properties that are operating as commercial on 175th that are not following the guidelines that they should be following for commercial properties. So I just want to make sure that they are definitely held to the same standard when it comes that time. Does that make sense?
Yeah, no, William Russell. And maybe this is more of a clarification, and maybe I can't ask the question or not, but sounds like you're saying if we do 1 and 2, then we do motion 3. And you don't have a choice on what's on there, right? If you've done something commercial or industrial, is there no opportunity to look at what's next? Because here we are in the storage capital of, Minnesota here with this plan. I mean, is it okay to ask a question on the clarification that you say, if you do 1 and 2, you have to approve this 3rd, which?
Would you, counsel?
I'd be happy to speak to that. That comment, and I believe some of the other comments are really appropriate for consideration when you're talking about whether or not to do the zoning amendment. All of those considerations, what might you like? Once the zoning is set, if an applicant submits plan for preliminary plat to develop their property that's consistent with all of our requirements, that's not a discretionary sort of legislative, well, yeah, but we don't like it. If our code requirements are insufficient, that's on us to further build out our code around preliminary plats. But we can't, assuming that the guiding is approved and the zoning is approved, and this complies with the zoning and all of the other performance standards in our code, this is a good application. And now what we're talking about is what reasonable conditions do we need as we're working through on the final plat? What are you going to build? What do we put into a development agreement to make sure that they follow through, unless they completely withdraw their application, which any developer could do. They proceed, they're going to have to proceed and be contractually bound by development agreement to do what we've agreed they can do.
Then I would ask that you make sure that it follows the code, because seems like there's a lot of creep that could happen here with roads that come through and then all of a sudden get access to, I don't know what the road is, that road that gets access to where the Messenrick property is, right? It's like there's a little creep where it's like, I'm not sure that it follows all that, because then you're getting access to areas that may or may not be commercial and you're going on non-commercial roads. So I just would ask that you really make sure that this plan meets your requirements. Because I mean, as the attorney says, if it meets the requirements, then have we gone through that to make sure that it meets the requirements?
Is there anyone else who wishes to speak?
Hi, Rachel Schlimmer. I live on 7512, 175th Street. And I would love you guys to drive by Messenbrick's 10-acre lot, because I do it all the time and it looks like a junkyard. He had a permit to use in a certain way, and slowly but surely he is now pushed way out of that bounds, and it looks horrible. I feel sorry for the people that actually have to live. So please do go look at what he's done. And he hasn't been fined for it. Nobody's kept him in place. So my biggest concern is you're going to give him all this extra land, and then he's just going to run with it and do whatever he wants because it's already been proven there's no consequences for his actions. So that's my concern, since I will have to look at all that stuff all the time. And that was never zoned that way when we moved in. So hopefully you guys consider that as well.
I'm not sure that you spoke earlier in the evening. Would you make sure that you fill out the, thank you.
Madam Chair, members of the commission, I'm Jennifer Haskamp. I don't know if I'm going to get another opportunity, so I thought I would just pop up here quick. I just wanted to make a point that there's kind of a two-part process here. There's the preliminary plat that shows you how we comply with the ordinance as it stands based on the zoning districts today. Then there's the second piece where I mentioned earlier that individual lots will be custom built for the user. And I just want to make sure that everybody's aware that some of those individual users will be subject also to additional requirements that will be things like conditional use permits. And so when those operators come in to purchase, construct, build, et cetera, there will also be that check and balance against how that lot gets developed, what kind of buffering or screening might be appropriate based on their configuration when they come forward. So the preliminary plat demonstrates that it can comply with all of your ordinance requirements for lot standards, dimensional standards, et cetera. And then there's the second piece of the process that once an operator, business comes to play, so to speak, and wants to develop that lot, they may be subject to those additional permitting processes as well. So just in terms of the checks and the balances and how you can respond to individual lots being constructed, those additional permitting processes allow for that. So just for background.
Are there any other folks wishing to speak this evening?
I just have a question, and I'm not knowledgeable about the city's policies, but how well written out are the policies for commercial and industrial use in our city planning, being that most of it is residential or rural? Is that well established, or is that more part of the 2050 plan or something that's still in the works since we're a new city? Because if we're talking about needing to follow through on whatever is established and follow the ordinances and things like that, do we have solid ordinances in place that are able to be capitalized on and followed through on, should these people not follow through with what they're supposed to?
Planner Strickler, would it be appropriate to comment on what our ordinances are? And what they govern?
All right, my troubles. The city does have ordinances that address commercial and industrial uses. There are existing uses in the city at this time that have been operating. And there are, as mentioned in my staff report, in terms of the preliminary plat, the application for this evening, they meet the lot size requirements and all of the lot coverage and other items. As there's a few subdivision ordinance things that we still need to iron out through conditions of the resolution and the preliminary plat, which is very common for this process, regardless of if it's residential or commercial in nature. But yeah, I mean, in all of the policies in terms of the comprehensive plan that contribute to commercial or industrial were, reviewed as part of the comprehensive plan analysis by myself and the applicant's planner, and the decision that was made. This year's split decision made this evening by the planning commission. So the city does have general policies and guidelines and ordinances that address these types of uses.
And to clarify, as Ms. Haskamp said, that when each property is sold and there is a request for there will need to be a conditional use permit request for
Depending on the specific type of use. So within our table of uses within the city zoning ordinance, outlines which uses are permitted with a conditional use permit, an interim use permit permitted by right within any district in the city, but commercial and industrial, there are several that require conditional or interim use permits. Not all, some are permitted by right.
Okay.
But it just depends on what the specific use that comes forward at the time. And usually that's done at a pre-application meeting type before any sort of building plans are submitted, so that owner or applicant is aware that they're gonna have that extra step before any type of building approval moves forward.
Thank you.
And our zoning code is online at the city website. And you could download that as a PDF file and you can look at all the different zoning ordinances that the city has currently on the books.
Thank you. Any other questions or comments?
Tina Mishka, just to follow up with what you had said and just our ordinances and maybe Ms. Strickler, you can help me out. My question would be, you said we're lagging and behind for the development subdivision ordinances. The ones that we have in the books right now for industrial and commercial, are they, when were those implemented? Like 5 years ago, 20 years ago? So I just want to make sure that because we are a new city and things are relatively new for everything now, are those ordinances up to snuff about what we want as a city and our vision as a city? So my question to you again, repeat, are those ordinances, are they relevant? Are they new? Are they old? And I know that we don't have very good ordinances, like she said, about subdivision. So we're working on that. I've been trying to work with some of the city councilmen on that.
Chair Olson, the public hearing should be about a specific application. And questions about whether our ordinances get an A grade or B grade or a C grade are really not in front of the planning commission right now. And but I'll say two things about it.
Yeah.
I'm not trying to shoot anyone down. The city's ordinances were inherited from the time when the planning controlled, this county controlled planning here. County ordinances deal with all the types of uses that were being developed here before and in other parts of the county. Every single zoning code in every city could use improvements somewhere, someplace, somehow. And so it's really not possible to answer that in the abstract, other than to say you have a full code on the books on this subject.
Okay, sounds good.
Thank you. Are there any other questions or comments? Any other questions or comments? Seeing none at this time, can I get a motion to close the public hearing?
Make a motion to close the hearing.
I have a motion. Do I have a second?
Second.
All those in favor, please signify by saying aye. Aye. Motion carries. All right, are there comments at this time by or questions that the planning commission members have?
I have one for Claire. So is there gonna be a cul-de-sac at 180th or is it gonna go on to 180th? Because it shows it both ways.
Yeah, so that's one of the elements that I was referring to in my
Okay.
last answer to the resident, was that we gotta button that up with what our ordinances require, which is that we don't actually
Right.
allow for permanent cul-de-sacs.
Mhm.
And like I said, that item was not addressed in my staff report, but we'll ensure that it will be for the council discussion, as well as further discussion with the city engineer and the applicant's engineer.
Okay. So,
And yeah, because it is shown both ways, you're correct, so
Right.
we need to get. So that would just be, should the planning commission recommend approval this evening, it would be one of those conditions I would recommend adding eventually.
Right.
Once you get to that.
because so if the road did go onto 180th, there should be turn lanes on 27 as well. And yeah.
Yeah, and that would likely then require additional review and discussion with Scott County.
Because the traffic study that was done, I don't think is very accurate, so just the numbers are way lower than they actually are.
Could I get some clarification on traffic studies and how they're conducted? Or if I understand correctly, it's a point in time. Is that accurate?
Typically, I think this traffic study outlined, how they perform their analysis. Some will do multiple points during a year, some will do, one point in time. There's also an overarching national standard that a lot of data is pulled from during traffic studies and analysis that they do reference in this report as well. That is very common within the industry.
Yeah. So one of the concerns that I've heard over it, throughout comment, other, just looking at the report, if we have stubs that eventually go into into some of these more minor roads, the implication could be that those are open and preferred routes of traffic when perhaps they haven't been built to that standard. Could you refresh our memories? Is that part of the development, the proposal? And if so, whose responsibility will that be financially? Will it be the developers for improvements on some of these smaller roads, or would that be part of the city's capital improvement plan?
Yeah, so at this time, we don't have an actual proposal for extension either to 180th or 175th. Within this preliminary plat application. There was some concept of those connections within other parts of pieces of this application that have come through, but for this application tonight, we don't have any of those connections proposed at this time.
From a development standpoint, what typically triggers that?
Triggers the additional extension?
Yes.
Yeah, so within our comprehensive plan, as well as a couple other road connection studies that the city engineer has done that I don't have in front of me, but that he has brought up within discussions of this application. There's future connectivity. We do have ordinances that require, or ordinances and policies within the comp plan that we want a through road network connecting throughout the city. That's part of where some of the subdivision ordinance prohibits those permanent cul-de-sacs, etc. So it's really, I think at this time, based on this proposal, that's stubbed for or ready for if something else develops there, and what that maybe phase 2 might look like for the development. Particularly, I'm thinking of 175th, where it is not proposed as permanent within this plan for preliminary plat.
It's just helpful. I hear what Commissioner Casey was saying about the need for turn lanes, and I believe that's correct on both County Road 21, and I would like to see that as a condition if that's applicable for County Road 27 as well. That is a really heavily traveled road, probably more than a lot of us realize. And I too, if I've been making turns, have almost been hit. Just given the curves, given some of the other aspects that make that road fairly heavily traveled, and also not as easy to make left and right turn lanes, turns into, depending on where you are. So if it's appropriate as a condition to think through that aspect of development at this time and conditions, I would encourage us to consider doing that.
Yeah, it could be appropriate, but to maybe ensure some language that talks about, if the 180th Street connection occurs.
Yes.
Right now, we're seeing it 2 different ways within the proposed plan, so.
Okay.
If for some reason it were to stay a permanent cul-de-sac, then, the condition would become irrelevant, but
yes,
that may just be an important.
What other questions and comments, concerns?
Well, there's been a lot of feedback from the citizens on outdoor storage. So with this, could there be a CUP or conditional for no outdoor storage?
So that would have to come within each individual proposed building. Yeah, when the time comes that they're ready to be developed and built.
That's a great question. I had that one too.
So I'm gonna go back to the roads a little bit. What's our policy, or do we have? I guess it's probably more of a county thing because they would mostly deal with 21, but so like U-turns. If it's gonna be right in, right out. There's gonna be a lot of U-turns, and that seems like a huge safety concern.
Yes, the county highway department's letter did have a comment that said that the traffic study analysis should include a discussion on the number of anticipated U-turns and how that might affect the safety at each intersection, especially at County Highway 27. And how larger vehicles can maneuver U-turn movements at the intersection. So any condition of approval, we typically always say, you know, any staff comments, any county comments within these memos need to be addressed before a final plat, et cetera. So we would get, hopefully, since the county has requested that information, hopefully get that within an updated study.
Along those lines are related, is there an ability if the stubs go through to require signage directing people to preferred access via, you know, those major county roads?
Yeah, that would, because likely it would be in county right of way, would be a great option for them.
So that seems like it would be a.
Potentially, I
Okay.
mean, but probably not out of the question, but that would again lead to more discussion with that department.
Is that something that is appropriate at this stage, or would that be appropriate at the stage of building? And having requests for building permits and or conditional use permits?
It could be a part of a preliminary plat conditions. That,
Okay.
you know, at least that the discussions and some general guidance has been determined, you know, before final platting.
What other questions, concerns?
I definitely think if the road does go through to 180th, we should make it come out as far to the west as possible, so it affects the chain and everybody else the least amount. Yeah, the farther to the east it is, it's, you know, if that's, possible to.
Yeah, I don't know the answer.
Cause it's hard to prove or, deny something that you don't really know where the roads are gonna be, so.
Yeah, I mean, any road design and intersection design on a city road, because the 180th is, would
Right.
be in line with whatever our, with what the city street design and intersection design standards are, which is in the subdivision code, so. Engineer
Right, but
Nelson
there's-
would ensure that this proposed road, should it continue through, meets that requirement, that there's really no, we can't go any different than what's allowed in that section.
Well, yes and no, I mean, I'm sure it says it's gotta be a certain amount of feet from 27, but that doesn't, that's
There's also-
pretty big.
Typically standards though on how, where intersections are going to meet up, and based on the alignment shown in some,
Yeah.
it does have it as essentially a four-way intersection
Right.
versus typically the safety of, if it's just a little bit over or vice versa. I highly doubt that it'd be able to move any closer to a county road based on their kind of spacing requirements and access and safety for any sort of traffic, what's the word? Traffic kind of
Stacking?
stacking, thank you, before turning out onto.
Right, yeah.
But there will certainly be additional discussion with engineer Nelson.
Are there other questions or comments?
Question, with the road comments that we're hearing, would the cost of that be up to the developer then?
The building of the road out to 180th would, is proposed to be paid for by the developer. All of the roads within this preliminary plat that are within the 90 acres, as well as the construction of the turn lanes out on the county road or County Road 21 that we have proposed at this time that he's been working with the county on designing. That would be his responsibility. And all of that gets sorted out and lined out within the developer's agreement.
Are there any other comments, questions? If not, can I get a motion, and I believe we need to frame it contingent upon approval of item 3.1
And 3.2.
and 3.2. Thank you. May I get a motion?
And the rezone.
So Claire, just to be, just a question, I guess, will they have the roads figured out before the city council votes on it, or how quickly will all that stuff get figured out?
Yeah, that would be the intent, and if not, the council will likely move based on what the code says, which is that you can't.
Cause, you know.
All right.
Chair Olson, I just want to reiterate, you cannot have a permanent cul-de-sac unless you meet certain criteria that's specifically listed in the zoning code or the subdivision code, such as existing wetland, etc. You have to meet all that criteria, and at that time, that's still under, like I said, what we're working.
Understand. All right, may I have a motion on this item?
Trying to word it here. Okay, so try this here. Assuming the council approves the re-guiding and the rezoning of rezoning applications, we recommend approval of the preliminary plat application.
Would you be open to an amendment to adopt the staff report into the record, accept the application, testimony, exhibits, and other evidence presented into the record, and recommend conditions if the preliminary plat is recommended, including item 1 and all outstanding comments from the city planner memo dated April 10th and city engineer memo of April 10th, 2025, and all outstanding comments from the county agencies in their respective memos dated April 7th and 11th respectively. Is that okay?
That covers it.
Okay. All right, we have a motion. Do we have a second?
Can I throw one more amendment in there? I just want to make sure that, yeah, all the road stuff is figured out before, because that's a huge deal, so however you want to.
Subject to having, how do we want to say that?
I'm, however you want to say it, but, yeah. we
Subject
can't-
to final decisions on roads or
On cul-de-sac.
or on the cul-de-sac.
And the U-turns is.
So
is-
the, okay. The U-turns. And the cul-de-sac. That's your condition.
Yeah, I don't think it's a good idea to have a bunch of people doing U-turns at 27 in Murphy.
Sure, yeah, that's okay. I'm just clarifying.
Yeah,
Yeah.
okay. So with those,
So, Madam Chair, if I may.
absolutely,
Those are proposed amendments to Commissioner Theorath's motion. He needs to accept it. as friendly amendments before there's a second, or we'll need some further procedures.
Okay.
I'll accept those as friendly amendments.
Okay. At this time, I would be asking for a second.
I'll second it.
All those in favor, please signify by saying aye. Aye. Any opposed? Motion carries. That concludes our public hearings for this evening. We have no items under number 4, which is general business. So at this time, we're on to item 5, which is adjourn the planning commission meeting. And since there is no other business before us, I am looking for a motion to adjourn tonight's meeting.
I make the motion to adjourn tonight's meeting.
I have a motion. Do I have a second?
I'll second that.
All those in favor, please signify by saying aye.
Aye.
Aye. Anyone opposed? Motion carries. Thank you, everyone. We appreciate your attendance this evening.
Good job, sir. Oh.